Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po rin, pero
Literally not true.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It is, wow. Seems like it's been forever. Seems like it's been forever since I've been live. I don't know why. Lena H., congratulations. You were first in chat today. That means we're happy for you. Mostly we're happy we're not you, honestly, because we're going to punish you with internet ownership. Everything IP related worldwide is your responsibility because you were prompt, you were punctual, and that's your punishment. That's it. So congratulations and good riddance. Lena, thank you. Wogger says, just got up. Perfect timing. Wogger, your timing could not be much better. I wish I just got up. Did I add a U in Kouri? Yeah, maybe I did just get up. Let's see. Kouri U Richins. Saved it. Fixed it. What you, Josh? I don't know what you're talking about. Yeah, we've got lots of things on the schedule today. The least of which is going to be. Whoa.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. That's all I got. I slept a lot last night, but not enough. I got 5 downs and 1 up. That's it. None of you can print 3D printers for a week. Well, just kidding. Just kidding there. It's hump day. We made it halfway through the work week. It's awesome. We do have a couple things going on today. First of all, we've got Judge McNally, who's just delivering a rant, a kind rant. I'm not sure how it ends because he's going when he started, so we'll see if it ends up mean or not. But we've got Judge McNally giving a little pontification on parenthood and what the state of the world these days. So we'll listen to him. He's not fired up. I think he's happy. It's a happy rant. We have birthdays to do this morning. Lisa Urban says it's my birthday, so we have that. Did you, Miss Sorry, have a fantastic birthday dinner? We did. Went to Rancheritos, or I'm not sure it's La Rancherito or Le Rancherito. I don't know what it is. I know Rancherito is part of it. Went in the wrong door. Apparently there's a door that I was supposed to walk in, and I went in the other door. I guess one's for pickup, one's for restaurant dining. Mrs. R.A. called it and said, I'm not going anywhere in public. It's my birthday, so I brought her dinner. But it was delicious. It was delicious. All right. I saw the buffer somewhere. There we go. Here we go. Thank you, Red Pen. Happy birthday to Barb, Lita, Lisa Urban, Lizzie. Oh, lots of L's. Lizzie was from yesterday. And Scott to do. All right. Wonderful. We will sing to these wonderful people. By we, I mean all of us, wherever you are. Stand up, take a breath, shoulders back, project your voice to the back of the room, blend your voice with a neighbor, and warm up with me if you will. La 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 la. I like to think that everything you need to know about singing is contained in that short instruction. Let's sing happy birthday to these wonderful people. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday to Barb, Lita, Lisa Urban, Lizzie, and Scott to do. Happy birthday to you. Barb, Lita, Lisa Urban, Lizzie, and Scott to do from yesterday. Happy birthday. I realize there are many wonderful days. Today's your special day, and I realize there are a million people you could have celebrated with and a million places you could have celebrated, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you, make your day just a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. It's the fastest I've ever got done with a song with that many people. The dancers are for you. Please enjoy the show. Great commercial endorsement voice. Let's see, pizza. I need to tag RA because I have no idea. Pizza? Let me see. What'd you say? What'd you say? Pizza. Hey guys, totally off topic. Do you remember when you all recommended a water bubbler for your cats? You had strong opinions. Which was it? I'm going to need you to lean on some other people there. I don't remember. I'll tell you this, my cat refuses to drink out of our cat water fountain. It insists on drinking rainwater out of the wheelbarrow. I don't know why. Because it's incredibly awkward angle to sit at. Lizzie waited all year for that. Well, if there was a question mark at the end, I'd be offended, but there's not. Drum solo coming up. Waited all year for that. That's wonderful. I thought it was going to be waited all year for that. Help me with the drum solo, would you? Mine drinks out of the toilet. What is it with cats? We got it. I was feeding it Deer Park water in the cat fountain that has a little flower on top that it can drink, and it's a fountain just for cats. At first, it had a little bit, and it's like, oh, that's cool. I like it. But now it prefers rainwater out of a dirty wheelbarrow, which it has to jump up on and land on the edge. And a cat landing all four legs on the edge of the wheelbarrow, it doesn't happen very often. And then he has to drink out of something like upside down. It's the worst possible way to drink, you think. Plus, it's not Deer Park water. It's whatever fell out of the sky here in North Carolina and whatever came with it. So there's that. It's wheelbarrow water or nothing. Do we even know if the judge in Kouri Richins will let the trial stream or will it be day delayed? We know it will be delayed. I don't think it will be a day delayed. I think it could be an hour delayed, something like that. I'm not sure exactly. Need to get rid of this because this will just make noise the whole time, and that's no good. Too many 3D printed toys. Let's see. One of my favorite places to be right here. Christy Gibson, thank you very much. Wonderful. 16 months, thank you. 1 hour delay starts at 12 our time, so that'll be this afternoon. We'll pick that up. I have to use ceramic cat fountains because my cat knocks over all the plastic ones. Mine wants to drink out of the bottle, and I'm not ready for that kind of princess behavior. Pour it in me gob. Yes. Fresh water or nothing else. But, all right, let's do a couple things. First of all, let's jump to Judge Dad really quickly, who was about to deliver a little talking to. Let's see what happens here. Just the state of the world, you know.
Anything that you would like to say?
I'm pretty sure that this time it's saved me and my baby's life. So I just wanted to say thank you for that. I'm really happy that I got caught that day. I'm 85 days sober. I go to a meeting every day. I do everything that I was supposed to do. And I want to help other women like me once I start getting through this program.
I'm sorry, I didn't hear that last sentence.
I just want to help other women like me once I start getting through this program.
Well, I'm troubled I'm going to tell you my negative comments first.
Okay. Start with the bad news.
You know, one of the things, I've been sitting here quite a while now, and one of the things that I always think of is how do I say this delicately? It's an impossibility for our society to improve if we don't have parents that care them. Can't do it. Impossible. And I'm not saying every parent, I'm not saying majority of parents, but certainly there's a sufficient amount of parents out there that don't get it. They don't understand. They just don't understand. You can't have parents that don't care about their kids. Because when they don't care about their kids, kids are smarter than we give them credit for, even when they're 2 or 3 and they don't even know that they're thinking. And they know when they're loved and they know when they're not loved. And they know when people care and when people don't care. I'm looking at this from and I told you I'm going to tell you the negatives part first. I'm looking at this and I'm saying, you have a young child in your car, and that child at the time, now you've got 5 kids and you're looking for a 6th, right? Right?
Yes.
And the child that was in the car was how old?
He was 2.
Okay. And you were pregnant when you were doing this, right? On its face, the child has no chance. On its face. No chance. I feel so poorly or badly about the fact that so many kids come into this world and they have no chance because they have parents that are not doing the right things. And I didn't say it's an easy job. I'm not sure any of us are equipped to do it, but it's certainly not an easy job. But we have to try. And we can't have kids when we're doing cocaine and hallucinogens and amphetamines and sedatives and inhalants, and now we're smoking marijuana and we're drinking. All of that, you don't need a legal scholar to tell you that. You don't need a substance abuse counselor to tell you that. You don't need a psychiatrist or psychologist to tell you that. You just need somebody with common sense to tell you. Just a little, they don't have to be overwhelmingly intelligent. Now, that's the bad news, because I'm just really floored by some of the things I read in. I really am. We just can't do this. We cannot do this. The good news is, I believe that you're sincere about this. But don't go out of here. And I'm telling you, I'm not saying you're going to be one of them. But I just have sensed, and I can almost see it when they leave the podium. There's either one boy, I got lucky and I'm going to stick with it, or judge didn't send me to jail. I'm okay. Now I can let my guard down. There can't be any letting of your guard down. If I want you to understand that if you don't comply and make it through sobriety court, you will do a year.
I understand that.
I hope you do, because there will be no ifs, ands, or buts about it. There won't even be a consideration.
I understand.
Now, so far, you've at least weaned yourself off the marijuana. But I'm telling you, nobody can argue with me that alcohol and drugs being consumed by a pregnant woman is anything but horrifically bad for the child. And I don't know how to put it to you this way, but other than saying, I mean, kids are bigger than we are, right? I mean, we should be doing everything we can to make them successful, to make them have values, have integrity, work hard, making them understand the world doesn't owe them a living. I'm going to cut you a break, but I do not want you to walk back from this podium, because there's going to be a lot of requirements here. And I want you to understand, you violate, and you're going to get every single day I can give you.
I understand.
Do we understand that?
I do.
Now, the prosecutor's office, they come out with these things, and they wanted me to send you to jail in so many ways. I'm going to read it to you just to remind you what they said. Sentence agreement of 60 to 90 days is determined by the judge with work release if eligible. Maybe waived, jail condition may be waived at the discretion of the court if the defendant completes a specialty court program.
That's the end of his rant. We're not going to listen to any of the rest of it. Yes, we do have a verdict to watch from yesterday. No, let me take you back. I just wanted to hear his rant about parenthood, and you have to do a better job as parents. All right. Let me take you back in case you missed this. Yesterday and the day before, we watched a trial out of Ohio, Warren County, Ohio, where a gentleman was charged with 24 counts. Half of them were election fraud and half of them were forgery. This was related to gathering signatures in an initiative to put an issue regarding redistricting maps on the ballot. He was a signature collector, worked for a company called ATM. And we waited. The jury went out. They deliberated. And we waited for an hour. And then I said, I'm taking my wife out to dinner. I'm done. And then we waited for another hour. And we got this. It took 2 hours of deliberation for the jury to reach a verdict in this trial. 24 counts Mr. X is facing. He's there on the right of your screen right now. Mr. X says he just went out and collected signatures. He has no idea if they were right or wrong, or if it's people's actual signature. The prosecutor says, because you either did it yourself or conspired with somebody else to do it. We don't have to say which one it was, but we know that these signatures are not valid. How did they know? They have on record every registered voter's signature on file. They compared the signatures on the form Mr. X turned in to the signatures on file, and they did not match. They also made a phone call to 12 people. Said, did you sign this? They said no. One of those people just happens to be the sheriff in this county, whose name was on the form indicating that he was signed for this, and he says, I never did any such thing. Mr. X, in his defense, says, it wasn't me. It might have been somebody else. One of those signatures on the back isn't even mine, saying it was my collection. He did a good job on the stand. He argued very eloquently. I believed him. The state did not. The state sort of gave up at the end of their case, honestly. They closed their questioning of the witness on the stand with, okay, whatever. I guess it could have been somebody else. No more evidence. So it was weak. That's what the jury went in with deliberations to, and we're waiting for the jury now as the judge is just pointing his finger around, talking about how things are going to go as soon as the jury comes in. We'll get audio in just a moment. This came in yesterday evening while I was eating dinner with my wife, and it was delicious. It was so good. Sound will be joining us in just a minute, as will the jury. Mr. X says he's a respectable member of society, works at a law firm full-time, was just doing this signature collecting part-time on the side just for a couple hours. Interesting point. The company he was working for had previously accused him also of forgery in signature gathering. All right, Judge. Do we have any audio? Can you help us out a little bit? I thought I'd timed it perfectly, but maybe I hadn't. Oh, here comes the jury. Here we go. Perfect. Wait for the jury. We'll get audio as soon as the jury's seated. The audio does take a hot minute. It's one of those ones where we're worried we will never hear what actually happened. But trust me, it comes in. It comes in.
Thank you. Please be seated. Ms. Morris, I see you're holding the verdict forms. Are you the foreperson of the jury?
Yes, Your Honor.
Can you tell me, has the jury reached a verdict?
Yes, Your Honor.
Can you please hand the verdict forms to Mr. Logston?
24 pages of verdict forms. There's page 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. There's half of them. Now onto the forgeries. 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, and there is 24 right there. So just to refresh your memory, I believe 71% of us, or 78% of us, believe this was a not guilty situation. Now the judge is comparing signatures with ones they have on file to make sure the jurors' signatures, which are on every single page. What is it? 388 total signatures they had to sign. Half the time they spent in deliberation was signing. You can buy a house with fewer signatures. The judge is going to ask the clerk for one of those little rubber thumb deals. Makes it easier to turn pages. All right. How are we, Judge?
All right. In the matter of the State of Ohio versus Exekia Rouse, the members of the jury, verdict as to count one reads as follows. We, the jury, being duly impaneled, sworn, or affirmed, find the defendant Exekia Rouse guilty of election falsification as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. Count two, the verdict reads the same. They found him guilty. This verdict form is signed by all 12 members of the jury. Verdict form for count three reads that they have found him guilty. This verdict form signed by all 12 members of the jury. Verdict form 4, they have found him guilty. This is signed by all 12 members of the jury. Verdict as to count 5 is guilty, signed by all 12 members of the jury. The verdict form for count 6, the jury has found him guilty, signed by all 12 members of the jury. Verdict as to count 7 is guilty, signed by all 12 members of the jury. Verdict as to count 8 is guilty, signed by all 12 members of the jury. Verdict as to count 9 guilty, signed by all 12 members of the jury. Verdict as to count 10 is guilty, signed by all 12 members of the jury. Verdict as to count 11 is guilty, signed by all 12 members of the jury. Verdict on count 12 is guilty, signed by all 12 members of the jury. Verdict on count 13 is guilty, signed by all 12 members of the jury.
Into the forgeries.
Additional finding as to count 13 is that the jury state did prove beyond a reasonable doubt that the victim was an elderly person. This additional finding is signed by all 12 members of the jury. The verdict as to count 14 is guilty, signed by all 12 members of the jury. The additional finding finds that the state did prove beyond a reasonable doubt that the victim was an elderly person. This additional finding, signed by all 12 members of the jury. Verdict as to count 15 is guilty. The additional finding is that the state did prove that the victim was an elderly person, signed by all 12 members of the jury. Count 16, the verdict reads that it is guilty, signed by all 12 members of the jury. Verdict as to count 17 is guilty, signed by all 12 members of the jury. Verdict as to count 18 is guilty, signed by all 12 members of the jury. Verdict as to count 19 is guilty, signed by all 12 members of the jury. Guilty as to count 20, signed by all 12 members of the jury. Verdict on count 21 is guilty, signed by all 12 members of the jury. Guilty verdict on count 22, signed by all 12 members of the jury. guilty on count 23, signed by all 12 members of the jury, and guilty on count 24, signed by all 12 members of the jury. Does the state wish to have the jury polled?
No, Your Honor.
Mr. Gibbs?
No, thank you.
All right. Ladies and gentlemen, that concludes your jury service. So all of the instructions that I gave you yesterday morning, you are now released from. Mr. Logston will return your phones to you promptly. If you'll go back to the jury room, we'll grab the phones. Pam's got some excuses for you for the last 2 days for those of you that need those.
You can use those for next time you get called to jury duty.
I'll be
They're
back
good
in just a minute
excuses.
to thank you personally for your service. All right, thanks.
All rise.
So the jury unanimously convicts him on all counts. Wow. Wow, wow, wow. He goes from upstanding model citizen to 24 time or 26
All
count.
right, at this time, Mr. Rouse, the court is
Convicted
going
felon.
to revoke your bond. I'm remanding you into the custody of the Warren County Sheriff's Office pending sentencing. I will order a pre-sentence investigation. We'll come back and do sentencing at a later date. Mr. Gibbs, I'll allow you to schedule that with, well, you'll be here tomorrow anyway, so you can schedule that with Ms. Yezo. Anything else for the record?
No, Your Honor. Thank
Anything
you.
else, Mr. Gibbs?
No, Your Honor.
All right, very good. Thank you all.
Thank you.
Mr. Gibbs, he's never won one that we've watched, right? He's always lost. I'm not saying that he's the bad luck charm, but prosecutors pretty happy with that. Clever Name says he's not even a cool felon. No probation or house arrest. No, he's going into custody. Let's see. What do you have in this pocket? What do you have in that pocket? Take everything out of your pockets. The lawyer's like, well, I don't want it. Is there a sword in that cane, sir? What's in your bag? Bag, phone. We're just going to stick that in there. Yeah. I'm not going to power it off. It's going to be there a while. Anything else? No, we're just going to take a quick peek. Just his meds and all. Do you have a wallet? You want to stick that in there? I've just got these papers and receipts and cards. Let's see, anything else? Oh, some pocket lint. Oh, nothing there. All right, sir. Do a quick pat down. Make sure you found everything. Yep, nothing there, nothing there. All right. Pardon my reach. All right, just check over here. Okay. Just stand there for a minute. Spread your legs. All right. Just purely professional reasons. Sorry about that. Oops, excuse me. Sorry. Oh, sorry about that as well. All right. Nothing there. How about a little back rub? You use a little back rub? Does the neck hurt? Does it hurt right here? Pinch a little tight there? We'll work on that spot for you. All right. More to follow, I promise. More to follow. All right, quite thorough. I'm convinced you don't have anything. And because you've got a cane, we're not going to cuff you. That's why we did the thorough pat down. So he's leaving the courtroom, but he's leaving in custody. He will not be going home. He'll be not going out the side door. And there it is. Level 5 felony. I think they carry a pretty lengthy sentence, so I'm pretty sure the judge is going to order them to be served concurrently all at the same time. So I doubt he will spend more than a year incarcerated. But the sentence will be set at a later time. Judge didn't even tell us when, so we don't even have that. We can show you, unfortunately. So we'll wait and see on that one. Obviously, we'll keep our ear to the ground and listen for any news to occur. All right, let's see. Judge Simpson has a criminal docket today as we wait for Kouri Richins' trial to begin its 2-day hearing later on. It looks like we have a Beard on trial today, which is, I think, have we seen this guy before? Mr. Crossley? Maybe I just recognize the shirt. got a call coming in. Hang on.
Call from Legally Blonde.
Legally Blonde, how are you doing?
Oh, living the dream.
Yeah, you and me both.
Right, I know. Did you talk about, was Miss Ari's birthday dinner perfect? Did they make guac at the table?
No, it was takeout.
Oh, okay.
She decided, before I even had finished live streaming, she switched her pajamas. She's like, I'm not changing for anybody. I'm not going out in public. It's my birthday.
Woman after my own heart.
So I said, I will drive. I'll get the food. We also picked up, we got her a new chair, right? And with her new chair, she needs a new blanket that goes with the chair because you can't have a chair without a blanket. So
exactly.
We picked out, my daughter and I went and picked out two blankets, and she loves them both. So we were going to return the one she didn't like. She likes them both. She keeps them both. That's the way it's going to go.
That's fair.
But yeah.
So I watched this live last night, and my reaction was the same as what I'm seeing in chat right now. And I was thinking, yesterday we talked about how we didn't get an opportunity to really compare the forged signatures to each other.
Yeah.
Or in comparison to what he claims to be his own signature. And even though he was convincing to us, maybe
the evidence told a different story.
Right. He's up there, but and he was convincing to us, but it was like, don't believe your lying eyes. Once you see it right there, and the jury is now comparing loops and swoops and all the other stuff. And I'm interested. I want to know, are the signatures that were forged, are they all in the same handwriting? Do they all look like they match?
At the beginning of the trial, we did see them. We saw the sheriff's name. We got to compare the information card that was on file.
Right, but
with the other.
We got to compare them to what signature the county has on file. We didn't get to compare the forged signatures to the other forged signatures.
I think we got to see both on the beginning. And the sheriff, this is the part that got me, because on the sheriff's, the handwriting where you spell out your name and address and everything, it was spit and image. It was like the sheriff wrote both of those, but the signature was way off. And so the names and the addresses that we saw initially, and we stopped putting it up, obviously the judge did, which is good because YouTube might have slapped us with a doxing type penalty. But the handwriting was different on every one that we saw, and very different.
Okay.
So
I didn't remember that.
Here's what I think happened. This is like my gut feel. If I can solve this crime with the limited information that I have. Okay. If I were to put out a guess as to what I think happened, I would say I think that somebody above him was involved. Okay, that's where the incentive starts. Right?
I agree.
That's where there's a reason. Why would somebody do this if there wasn't a reason? Why go to the extra work for
who benefits from it?
Yeah, there's for me that's a big question. It's not needed for proving the case, but the why has to be there for me for it to make sense.
I agree.
And so somebody above him has to be involved, and maybe it was coordinated, like on a big scale. Maybe I'm putting on a tinfoil hat here, but maybe. Sure. They were dropped off.
They were colluding.
Hey, you should go to Kmart. And they went to Kmart, and it's like, wow, there's a line of people here waiting to sign your petition. Maybe they were dropped off by somebody else, and they each had a name they're supposed to write. And then they get dropped off at another location. And then those same people who signed there get dropped off at another location and sign under different names or something like that. I don't know. But it's not a stretch of the imagination when you have a billionaire, be with a billion with a B, right? Who's like, I would like to change politics. I will use my money to do so. And they can pay to make this happen. Okay? Money is not an issue at this point. They can make things happen politically by just, throwing their money around.
Yes, but that still isn't good enough for X, because he didn't get the bonuses unless there was a under the table behind the door bonus between him and he had a supervisor that lost his job, right?
Yeah.
Did they say why he lost his job? I can't remember.
X said he was fired as well.
For forgery?
He didn't say. It was just sort of like we both got fired.
Okay.
But I think the lawyer, his defense lawyer, should have fought to keep this information out. And I realize X volunteered it under police, not under coercion, just under initial contact. So it would be difficult to keep out. But the information that he was accused of this before, man, that did him in. That was terrible. That's just like, why is this not kept out? You can't tell somebody. It wasn't even a conviction, right? It's not even like.
I disagree. I think it shows that they didn't have anything. That's why they gave him his job back.
I don't know.
It's almost like they know it's happening, but he passed muster so that he got to come back. I don't. It just seems bizarre to me.
It's crazy.
I still on my own would like to see the forged signatures next to one another.
Well, the judge. You can make the call. Call Justin. He's probably got a copy for you.
Hi, Justin.
This is your neck of the
remember
woods.
me? We met that one time.
Can you hand me the court file for that from yesterday? I just need to
Please,
check
did I
something
mention
real
how much
quick.
I love your tweed jacket and your elbow patches?
They really do it for me. Awesome. I hate to push you off the phone, but Snoop Dogg.
No, that's fine. I'm
Snoop
done.
Dogg's
That's all
on
I have.
trial right now. Apparently.
Yep.
Hang on one second. Let me
What?
just,
Snoop? My Snoop? My fellow gangster rapper?
Look, no, it's not him. It looked like him. I thought for sure this was Snoop.
It's with him and the girl that he was with.
I feel bad.
And I was trying to hurry up and get to him.
We'll see you.
And I did stop at the railroad tracks. I knew they were malfunctioning because I was just there 2 hours prior, and they was actually there working on the railroad tracks. They was going up and down.
We're in Oak,
but
Royal Oaks.
I failed to tell the officer that because I was too busy running my mouth about whether you could or could not go around the railroad tracks. And
around the arm that came down.
Yeah, they were going up and down, and they was the people was there working on the railroad tracks, so it was going up and down. And
isn't that from a Snoop song?
I was trying to get to my son, and I didn't get a chance to tell the officer that, and I know he didn't know the situation I was in, and I'm a father. Me and my wife, we had 5 kids. We lost 2, one to cancer and one to suicide. Within the last 3 years. So
I'm sorry.
I guess you could say expectations, or I just be really on pins and needles when it come down to my kids, and I know the officer's not responsible and don't know what I was going through, and I didn't get a chance to say all that to him, but I know I did kind of just I didn't curse at him or anything like that. I just know I was a little bit hostile because I was trying to get to my son, and that's the main thing. I'm not worried about the fine. I'll pay whatever. My main thing, I wanted
about
to,
the money.
to
I got the
apologize to the officer for the way I acted.
Okay, so this is not Snoop.
Is there anything you want to add to this, officer?
Magistrate, on the citation for the improper lane use, I'd make a motion to dismiss that, but we're going to leave the driving around the railroad sign.
Yeah.
Yeah, you
Okay,
can't do that.
So, Mr. Jones, the citation for improper lane use is dismissed. There's no fine on that. The railroad crossing, there was a point in time, I want to say, in the very end of the 1990s or the early 2000s, the city of Royal Oak had more traffic fatalities with trains than any other place in the state.
Now they have more
there
traffic
has
tickets
been
for parking.
an extreme amount of care given to modifying the crosswalks, modifying the signals, and maintaining it, because there's no halfway with the train. And when a person walks across the tracks and gets hit by a train, their body parts are spread about a quarter mile. It is extremely gruesome.
Yeah.
And there are a fair number of people who are coming upon the tracks, whether on foot or in a car, that have had some adult beverages, and that doesn't help at all. But there is no close tie with the train. And the city has enforced the regulations regarding stopping for the train. And it has saved a lot of lives. I mean, for a small town like Royal Oak to have more than anybody else in the state was just awful. So this going around the arm just can't happen, because when you're there, you can, there's an angle to the road and you can look southbound or kind of, and think it's clear. But the trains go both directions and there's two sets of rails.
Yes.
And a train does not have a speed limit. And those trains go through at least 45 miles an hour.
They do have a speed limit.
Which is more than 67 feet per second.
Oh, he did the math.
And any mistake is fatal.
67 feet per second.
It's imperative that drivers not go around those arms. So the fine on that one is $150. The other one is dismissed. You can pay the fine online or by mail or at the courthouse counter.
All right.
Thank you, Your Honor. I totally agree with you.
Get back
and I apologize again.
Get back to your label.
Appreciate that. Thank you.
Thank you. Have a great day.
Can you see why I thought it was Snoop, though? Not initial. Okay, hold for a second here. We're gonna go back to Judge Simpson. I've got to recognize a couple people. Christy Gibson, thank you very much. One of my favorite places to be, right here. Thank you for 16 months. Lindsay Ross, welcome to the gallery. Sherry Smith gifted a membership. Josh gifted a membership. I think he gifted about a dozen. Thank you very much, Josh. It's funny how those lined up. Susan Bastrick, member for 24 months, made it to 2 years. Happy New Year, everyone. Thank you. Congratulations, OG. Let's see. We've also got Kazam Cat, member for 28 months, also an OG. Great place to spend my time at work. OG. Jersey Prods, member for 14 months. Officially longer, unofficially best place for court watching on the interwebs. I think Melissa P., I think you're also past the 2-year mark. Did I see that? I think you passed your 2-year mark. OG, Melissa P. Welcome. There it is. Red pen, could you perhaps get the boss man to acknowledge, hey, it's a difficult job here I'm trying to do here, but I caught it.
If I may, Your Honor.
Back to Judge Simpson.
So Mr. Cook needs to review the video on this case, which I believe is dispositive of the whole matter.
Greatest of all time.
I'll resist telling you what I think happened.
I figured that would be the case. February 4th, will that work for you?
It will. Is this a 9 a.m. case?
Well, I set everything at 9 a.m. and then what I do is they're divided into blocks, and typically private counsel would be early in the morning.
Okay. Right. Very nice.
February 4th, 2026, 9 a.m.
Your Honor, it's nice seeing you, and thank you.
Good seeing you, sir.
Okay.
All right. Thank you, sir. Court calls case.
Britta Aller, 32 months. OG.
People.
Great place.
That name I got right.
31 months, another OG.
It's 4 letters and really only 3.
Thank you.
Good morning, Judge. Hugo J. Mack, appearing with Mr. Issa. Please state your name for the record.
Hassan Issa. Thank you, sir.
Your Honor, we've discussed the matter with the prosecutor. Believe we do.
How'd that go?
It went well.
Did it?
It went very well. Thank you so much.
Let me ask you, Mr. Cook, how did it go? But anyway, go ahead. What do we do?
Be very well. Does the court have a copy of the Secretary of State return? And if so, does that mean that license is valid?
If not, I've got a picture of his license here.
I couldn't even answer the question.
Well, no, I'm always trying to.
You're going to try to show me a picture.
No, not me, Jeff.
You know, it's so funny. Mr. Cook is asking me for the official, report of adoption. Hugo Mack, I got a picture, man. His license is valid.
It's a beautiful thing, Jack.
It is. This case is dismissed. All right. Thank you, sir.
Thank you so much. Appreciate you.
Judge Simpson's in a good mood today.
Thank you.
Boy, now there's going to be no controlling Hugo. He got a victory.
Got a victory.
You know, Judge, the acoustics, I can still hear that.
Sorry. I thought I was whispering. Court calls the case. People versus Edgar Constant. Is it Constantinier?
Ready, Your Honor.
Edgar Castellanos.
Yes.
Mr.
that's what I meant
Puta.
to say. Okay.
Good morning, Your Honor. Julian Puta on behalf of the defendant, Edgar Castellanos.
Right. And this is an arraignment. Folks, you just have it as a pretrial?
Pretrial.
I don't see any arraignment information. He was not arraigned. Counsel, as to the arraignment, you waive formal reading, your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. All right, and what are we doing on this
That was
today?
a quick arraignment.
Your Honor, I'm asking if we could have the matter set for a final settlement conference and trial date.
Sure, we can do that. Jury final settlement conference in this matter will be set for February 6, 2026 at 9 a.m. Jury selection, if necessary, will be February 9th, 2026, 8:30. Both of those proceedings are in person. I will set the defendant's bond in this case in an amount of $5,000 personal recognizance. I'll order standard conditions, including no assaultive behavior, possession of any weapons. There's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, sir.
And does the defendant have any other alcohol-related offenses in his past?
I don't believe so, but let me double check. No, Your Honor, this is the only.
No? Okay, then I won't order testing. I'll just order those conditions. All right? Thank you, folks.
Your Honor, I do have a conflict on February 6th. Is it possible to have it at 10 o'clock instead of 9?
If you let us know that you're showing up at that time, but I set all of those final settlement conferences at 9.
That's fine.
If you just make sure my office is contacted, letting us know that you'll be delayed about an hour, then we'll work with you.
Thank you.
All right, thank you.
It's nice that it is the private attorneys first because they're paying per hour for the attorney to sit there.
The people versus Leaky Church.
Morning, Your Honor.
Leaky Church.
Judge, good morning
Oh,
to you and the staff. Vincent Haysha, with and on behalf of Zeke Church, who's present through Zoom, obviously without objection.
Did I say Zeke? Yeah, I did. Zeke
Church. New year.
State your name, sir. Zeke Church. Thank you. It's going to be a day. All right, what are we doing?
If I could, Judge, Mr. Cook and I have been in contact. We're exploring ways to resolve this. I think probably best at this point to set for final pretrial jury selection, see where we're at. We may resolve it, we may not. We'll see.
Jury final settlement conference will be February 6, 2026, 9 a.m. Jury selection, February 9th, 2026 at 8:30. Both of those proceedings are in person.
That works, Your Honor.
And when you show up in person, I will get your name right. All right? Thank you, sir.
Thanks, Judge.
All right. Court calls the case, People versus Joseph Crossley.
Morning, Your Honor.
Beard on trial.
Good morning, Judge Lawrence H. Margolis with and on behalf of Mr. Crossley. Joe, please unmute yourself and state your name.
Joseph Crossley. What are we doing?
We'd like this set for a final settlement conference and jury trial, Judge.
Jury final settlement conference will be set February 6, 2026, 9 a.m. Jury selection in this matter, February 9th, 2026, 8:30. Both of those proceedings are in person. Bond with its conditions will continue.
Thank you, Judge.
Thank you. Court calls the case, People versus Adib Shawaka.
Lawrence Margolis on behalf of Mr. Shawaka, please unmute yourself and state your name, sir.
Yeah, Deep Shawaka.
You need to put your chain in, please.
Yes, sir.
No bling. Put your chain in.
Similar to the last case, Judge, please have this set for a final settlement conference and jury selection.
Jury selection or jury final settlement conference, February 6, 2026, 9 a.m. Jury selection, if necessary, February 9th, 2026, 8:30. Both of those proceedings are in person. Bond will continue with its conditions.
No chain.
Thank you, Judge. Have a good day.
Thank you. You do the same.
If you wear your chain, the judge will give you another one.
People versus Jamonte Love.
Your Honor, ready to go for the people?
Why no chain? It's just a judge thing.
Good morning, Your Honor. Shauna Basti on behalf of Jamonte Love. Mr. Love, state your name for the record.
Jamonte Love.
Thank you. All right, what are we doing? Don't everybody speak up at once.
I believe we reached an agreement on this one. I apologize. I have a complete form here physically. I was unaware the counsel was appearing via Zoom. I can get a digital copy over to defense counsel for signature if the court wouldn't mind passing this. I apologize.
So it's a guilty plea of some type?
Correct.
All right. So what I'll do is, because she's going to have to get it to Mr. Love. I can do it one of two ways. I can adjourn it out, or I can call it up in the next block. Can I fit it into the next block? Yeah. I can call it up in the next block at 10.
I'm fine with either of those, whichever works best for defense counsel. I don't know if she has other hearings this morning that.
Counsel, which would you like us to do?
Mr. Love, can you are you able to sign this document so you can take your plea today?
Yeah, you're going to send it to me and I just got to print it?
Yes.
And sign it.
Yes.
And send it back.
All right. So what I'll do is I'll just pass this, let you guys work out the logistics during my break, and then I'll call it up in the next block. All right?
Thank you.
Perfect. Thank you, Your Honor.
Thank you. Court calls the case. People versus Marcus Stewart.
People.
Good morning, Your Honor. Tia Brock on behalf of Mr. Stewart, who is present via Zoom. Mr. Stewart, please unmute and state your full name for the record.
Where's your client?
I see his name there, but
I did see him as well.
Marcus Stewart. Thank you. You'll need to be someplace stationary, sir.
I'm sorry.
What are we doing on this?
We'd ask the court for a final pretrial date and set for a jury trial as well.
See the Chili's?
Jury final settlement conference will be set for February 6, 2026, 9 a.m. Jury selection, if necessary, February 9th, 2026, at 8:30. Both of those proceedings are in person. All right. Bond will continue. Thank you.
Perfect. Thank you. Have a good day, everyone.
All right, you do the same.
Now he turns around and goes back inside, goes back to work.
Right. Court will stand in recess.
All right. We are court hopping a little bit today while we wait for the Kouri Richins trial, which is expected to start around noon. So that's going to be fun. It's a 2-day hearing in the Kouri Richins trials. We're getting close to the kickoff of that trial. That's going to be an interesting one. Let's pop back in on Judge Dad to see how Mr. Judge McNally's doing.
Trial, right?
Correct.
Is that what you want to do, Mr. Laney? Yes. You have the constitutional right to a jury trial. By waiving a right to a jury, I will be the one who will solely decide your guilt or innocence. Do you understand that? 6 people will be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. Do you understand that? Yes. Anybody forced you to give up your right to a jury trial? And you still wish to do that? All right, I'll accept the waiver, and we'll have a formal hearing on the other 2, the civil infractions, on that date. Are we going to be able to do this? Now I've got to go further, right?
His attorney is a full.
Is this going to be a plea or something, do you think?
Hopefully, Judge. We're looking at a resolution here, yes.
Southern Treasure, congratulations on 24 months. Makes you an OG.
Heather, I don't want to have to move all this. I'm already on the board on this, or soon. Do I have to move this all the way to February?
For a jury date, Judge? Is that
no,
what we're
just a bench.
Oh,
just
yeah, for bench press.
I'm off on the 21st.
Yes. I talked to Mr. Urick about the 28th and having an afternoon docket, but I have not heard back yet on that.
Is he good with that date?
January 28th? Huh?
Yeah.
Are you good with January 28th?
No, I mean, did you talk to Mr. Urick about that?
We did not discuss a date. We thought, Judge, you were going to push it out to the 21st.
I was, but I'm not here.
Okay, I can run in that.
No,
Your Honor?
Are you good on January 28th at 1 p.m. for a bench trial on this?
I am going to, that would be for Mr. Fanego, so I would have to check that, Judge.
Can you check now?
I can check now. I can't guarantee a response now, but I will certainly check now.
I'm curious what.
I will come in with the information as quickly as I can. If you could pass the matter, Judge.
I'll pass it. Thanks.
Thank you.
Bye. All right. Have a seat 1 second, okay? As soon as he comes in. Charles Lamont Towns. 25W839-232 OM.
Rebecca, thank you very much. Give Buttercup a pat for us. Thank you, bite me. Let's see, Southern Treasure, 24 months. That's wonderful. Selena K gifted a membership as well. A lot of people are saying, we think that the Kouri Richins trial is not public. I'm just saying, I saw a tweet from Law and Crime saying that they would be allowed to show it on delay. Let me just check and see.
You find him, Mr. Towns?
No, the officer was full.
I think it was Kathy Russin. It's a 30-minute delay.
Shaquila Shante Harvey. 25 W838266A and B. Your name?
Sure.
You're another one. You are another one. You had a ticket on the A file. It looks like you posted a bond on that and a bond on B. Did you talk to the prosecutor yet?
Yes.
Okay. Did you have a lawyer?
No.
Yeah.
So you're going to plead guilty to allowing an unlicensed driver to drive, right?
Yes.
What am I blocking? Sorry, I'm in the way.
If you plead guilty to allowing an unlicensed driver to drive, possible penalties are up to 500 fines, 90 days jail, costs, or all those. Do you understand that? Did you sign, read, and understand the advice or rights? If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yeah.
So he's also going to dismiss the suspend and the no insurance, right?
Lucky.
All right. Did you sign, read, and understand the advice or rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that? You have the right to a lawyer. If you want one, I'll give you one still. Do you want a lawyer?
No.
To the charge of allowing an unlicensed driver to drive, how do you plead? Were you in control of a 2017 Chevy that was being operated on Western Ford Lane in Woodhaven, April 3 of 25 at 1:52 in the morning?
Yes.
Allow somebody to drive that was unlicensed. And that was you, correct? Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Please accepted. Where's Kyle Robinson?
Kyle, get up here.
Is he going to let you apply the bond?
Yes.
You're going to have to call him and have him call the court. What's his relationship with you?
My husband.
You go out the hallway, call him. I'll accept your plea. I'll dismiss the suspend. I'll dismiss the no insurance. Where does he work?
Yeah, it's in John.
How do you want me to handle this, Heather?
As far as the bond, Judge, he can
What's in her husband's name?
He can call up and ask for the cashier, Stephanie, and Steph will talk to him, and she can get his permission.
All right. So I'm going to have you call him, and then he's going to call, right? I'm going to write it down for you. Okay? And he can call our cashier and tell us, and then you're going to come back in here, and I'll send you. What's Stephanie's extension?
I believe it's, let me double check here, 212.
Come on up here. My recorder's going to hand you this sticky note. And you can call your husband right now, not from the courtroom, go out in the hallway. Call him and tell him that, ask him if he's going to allow you to apply the bond, assuming he is. You're coming back in here and I'm going to sentence you, okay? Thank you very much. I'm still waiting on Mr. Carmen, right? Thornsberry, Johnny Luke Thornsberry, 25W839-358. Mr. Carmen, I'm going to need you in the courtroom, sir.
Mr. Carmen,
You right in?
Get in here.
Your name, sir?
Johnny Luke Thornsberry.
You're charged with possession of LSD, it says, possession of cocaine, Schedule 2. You have the right to a lawyer. I'll be happy to give you one. Would you like a lawyer?
Yes.
It's LS. I didn't hear no LS.
And when you look on the bottom, it says possession of cocaine. I don't know why you came up with LSD.
Okay.
So hang on. Don't tell me you had anything. Don't admit to anything right now. I'll give you a lawyer.
You need a lawyer.
Talk to your lawyer and you can explain all that to your lawyer, okay?
Okay.
And then come on back in here as soon as you and your lawyer have talked, all right? Thank you very much.
It's just giving out lawyers
People
like
against
candy.
Charles Lamont Towns, 25W839-232.
In Kansas, they make you
Come on
fight
to the
someone to get a
podium,
lawyer.
sir.
Here, you just get one no matter what.
State your name.
Charles Towns.
All right.
Hands out of your pockets. Thank you. He heard me. Uh-oh. Judge has his arms
Wow.
folded. This is not good.
Appearance.
Michael A. Carmen, B73824, on behalf of the defendant, Your Honor.
Mr. Towns pled guilty previously to malicious mischief. The agreement was, I believe, that it be taken under section 771.1. It was referred for a pre-sentence report. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Your Honor, yes, I have just two additions to make. As far as Mr. Towns' employment status, he is still working at Ford, earns the same amount. However, he's going to be laid off on and on starting January 19th. So there's going to be a total layoff of 12 weeks, but it's going to be off and on.
I need to ask, let me ask you a question. I'm sorry. I need to ask if Joseph Naday from Gorno Ford is here. Joseph Naday. Come on up here. I'm sorry. I should have asked before. My apologies. Your name right there, that's a microphone, believe it or not, and right to your left. Your name?
Joseph Leon Lyday.
Okay. I'm going to let them finish and then I'm going to come to you, okay? Go ahead, Mr. Carmen.
So, Your Honor, given the 12-week in total layoff, which is going to be on and off over the next few months, Mr. Towns is going to lose a fair bit of income due to that. I should add, for dependent children, he has a son. He's 19, but he still fully supports them. So, of course, that factors into his income as well. But otherwise, I've gone over the recommendations of probation. I would ask that the court adopt those pleas.
We did the verdict about 45, 50 minutes
Is there
ago.
anything you would like to say?
No, it's not. No.
So I read the report, Mr. Naday, and I just want to make sure my understanding of everything is correct. The defendant came over to Gorno Ford, and ultimately, because he was unhappy, he slammed a door and the window broke, right?
No, Your Honor.
What happened?
So he did leave aggressively. He slammed the door, but the window did not break. He punctured the wall behind the door.
I'm sorry. Okay. I'm sorry. All right. I'm sorry. The door swung open with enough force to damage the exterior of the building. All right. Do you have a bill for that? Did you cover, was it covered by insurance? Did Gorno Ford have it repaired? Did you pay?
We repaired it in-house, sir.
Repaired it in-house. So
there's no restitution that you're asking for?
No, we're just asking that he doesn't return.
Is there anything that you would like to say, Mr. Carmen, in addition to what I just said?
Your Honor, nothing further. I will note the no contact and no return to the business as part of the report.
If I were the business, I'd be
What
like,
was the service
I'm
that
also
was
asking
performed?
for
Just a oil change. So the individual came in, around 2 or 3 o'clock, met with the service advisor, dropped off his vehicle. We shuttled him home. The agreement was we were going to be done with this vehicle by 6. I believe we got done with it at 6:05. We went and picked him up also. And then that oil change was free for another issue that we had previously. So we gave him a free oil change. We shuttled him home back and forth. He came back upset that it wasn't done at 6 o'clock. And I came out of the office, apologized to him. He was fine when we talked. When he exited the building, it was pretty aggressive. I went out there in front of him and asked him why he slammed the door. It was later that we pulled the video that he kicked the door open. But I told him I was going to call the police. He came up pretty aggressive. I don't recall what was being said. We were both yelling at each other.
You and him?
Correct.
Good.
I told him I was going to call the police. He did stay for about 5-10 minutes. Then he left. He did get there. Detective called me the following day. They reviewed the footage. And that's the last I've heard about the case.
Okay.
Would you like to at least give a commercial for your
Tell me, what, so you were upset about 5 minutes?
That's a total lie. It was a buildup. I shouldn't have kicked the door.
Okay, I got it. Hang on. I want to know why you were so upset
Start with
that
the
would
total lie.
cause you to fling the door open and cause
Because that was the third time.
Let me finish. I want to know why it was or what happened that made you so upset that you would fling the door over and cause about $500 worth of damage to the exterior of the building. Now you can tell me everything.
That was the third incident that I had coming up there. So
on this day?
No, third time in a row that I came up there. It was he know about them all because a manager had got fired for the first week. So
say that again.
I said he knows about the incidents, about 2 or 3 of them, because the manager got fired from the first. That's why he's the manager now, because the first one got fired because of the incident with me.
Is that true?
No, sir, not to my recollection. I've been there 15 years and we didn't fire an employee due to a customer interaction.
It wasn't the interaction, it was the service that he did.
Don't talk to him, talk to me.
Oh, it was the service. It wasn't the service. It was when I went up there, the guy broke the nuts on my car live. The guy who did the front wheel alignment, he know the whole story. That's why they gave me was giving me a free oil change because of what they did to me and how long. So, but this last time I went up there, I dropped my car off at 10:30 in the morning. 10:30 in the morning, I dropped my car off. This is probably on the paperwork. Around 3 o'clock, 3:30, I started. They said it was going to be 3-4 hours. About 3-4 o'clock, I called. And, I had other appointments. So called about 3 or 4 o'clock. Basically, every hour I called, they told me we're on our way in an hour. So from 3, they closed at 6. So at 3 o'clock, 3:30, they told me somebody's on their way. I called back at 4.
To pick you up.
Excuse me?
Somebody's on their way to pick you up.
Yes.
Okay.
So at 3:30, I called them. Nobody came. 4:30, I called them. Nobody came. I know they closed at 6, 5:30, I called them. Again, like, what's going on? So they came and got me about 5:45, and me and him talked about that and everything. And yeah, on the way out, I missed a couple points. I was angry. I kicked the door. I did.
Okay. Sometimes people get busy. I'm not condoning.
I understand that. That was. I don't condone it. I don't agree with. That was the third incident, and I was, fed up, and I had a lot going on in my life, and I was triggered. So, yeah, it was. They didn't get the car at 3 o'clock. They got the car at 10:30 in the morning.
Okay, but still, sometimes that happens.
I was wrong. You're right. A lot of things happen. You're right. I understand.
He's saying I was wrong. He's like, but they were late with my car, so I kicked the door. Parenting classes. Judge Boyd would order parenting classes at this point.
See, I just, I'm not trying to.
Adam, welcome.
We all lose our cool a little bit. This just seems a little bit over the top, don't you think? You're kind of justifying your conduct here.
I didn't justify it at all. I said I was wrong 2 times. I didn't justify it. I don't justify it at all. It was stupid and impulsive. I didn't justify it 1 time.
You make more than $910 per week, right?
No, I don't.
How much you make per hour?
$40.
40 times 40 is 1,600. How do you come out to 910? Net.
Taxes.
Well, we all pay taxes. This is the United States.
I mean, I can show you a check right now.
No.
$835.
Well, but they're taking out what? Child support or something?
No, I don't pay child support.
Are they taking out
I single zero.
Hang on. Are they taking out some
401k
car payment, or are wages being garnished? There's no way they're taking out $700.
Single zero and a loan from myself.
All right.
That they're taking out, for hardship loan that they're taking back from my pay. Yeah.
Okay, so they are taking stuff out.
Okay.
Makes
Anything else,
$40 an hour.
anybody?
Your Honor, I'd like to speak.
Sure.
Gordon's been around for a long time. We're all very family oriented. I don't want to see any harm come to this gentleman. We're very second chance. We just wish that he doesn't return. That's all I like to say.
Well, I'm not sending him to jail.
And I don't have a problem. I've been going on for how many years? Yeah, I've been going.
All right, talk to me now.
I've been going there for years. I had no problem spending my money in. Years.
All right, but
The company's like,
well, I'm just going to tell you one thing, and then I'm going to sentence you. And this is not going to be overly oppressive, but you have to understand something. You're telling me that you were wrong, but then you're justifying your conduct. So I don't know which it is, but I'm going to let it go. 12 months probation. I'll take it under section 771.1. That was the agreement. You cannot leave the state without the consent of the court. You cannot violate a law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to attend the anger management weekend program. You're not to enter 21111 Allen Road in Woodhaven. You're not to have any contact with Joseph Naday. No contact with him. You cannot write, phone, see, text, email him, communicate with him, have anybody else do any of those things for you or on your behalf. 1 day court work program. There's a $35 charge for that, and 1 day of community service. So you're going to do 1 day court work. It'll be a Saturday or Wednesday. There's a $35 charge. You're going to do 8 hours of community service. I want that done by February the 15th. And you're going to pay fines of 100, costs 100, 75 victim's rights fee, $50 justice assessment, 3 1/4. Probation fees are $240 for 565. Attorney fees, I'll only charge 40. That's 605. And your court work program fees is 640. That's 35 plus the screening fee, $700. Restitution, if any, to be handled through civil litigation. So no contact, don't go back there. 8 hours community service by February 15th. We'll schedule you a day on the court work program. And that, sir, is pretty much it, except I just need to check out something. You do need to go over, I'm going to order you to go over to Woodhaven and get fingerprinted and photographed, okay? So you have to go over there today. You have to go over to the Woodhaven Police Department to get fingerprinted and photographed by 2 p.m. today, okay? By 2.
So you go to Woodhaven Police, that's the one on West Road?
Correct. West and Hall Road.
Don't kick their door open.
I'm going to give you a review hearing date. You go down the hall, you'll get your review hearing date in paper form, and then you'll go over to probation, and you'll be instructed, and then you'll go over to Woodhaven. I filled out an order
Drive
for you to go
Chevys
over
from
there
now
and
on.
get printed and photographed.
Wow.
All right, Heather, what do you have for me in 12 months?
That'll be January 6th of 27.
Review hearing date will be January 6th of 27 at 8:30 in the morning. And do you have, how much of this $700 does he have?
I don't have anything right now. I don't have any money right now. I'm going through some things right now. I have a good job.
Okay, slow down. It's fine. Tell me when you think you can pay this. Hang on, slow down. I'll set you up on a payment plan. Tell me when you can start and how much you can pay.
You can start me up for Fridays. I'm gonna be on it for a year. You put it $50 a week. Well, I'm sure I'll pay it way beforehand, but I don't want to over
You pay $75 a week, and I'll start this beginning on February the 27th. And if you don't have the money, no problem. You come and talk to me or Zoom in. You call the court and ask for an extension. I'll be more than reasonable. You okay? So if you don't have the money, again, you just don't worry about it, but you gotta call and Zoom in, or you gotta come and talk to me, and I'll be happy to give you an extension. Just don't.
Just one more thing, my client is asking for permission to leave the state January 19th. He's planning on visiting his brother in New Jersey. His brother is ill.
Okay, give me the file back, Gene, or wherever it went. I need it back. How long are you gonna be gone?
Just a weekend.
All right, I'll just say can leave state between January 19th and January 26th. I'll just say, I know you only said you're only going to be gone a couple days, but just in case, you can leave state between January 19th of 26 and January the 20th. I'll make it January 27th of 26 to go to New Jersey. Okay.
So my issue on this
anything else?
Is the fines.
Thank you very much. Good luck. Thank you, gentlemen. Have a good day.
His lawyer gets
Labadie.
$40.
Reed Dean Labadie Jr. 25W18.
That's only $5 more than the fee for doing court work for a day.
Remember, on behalf of Mr. Labadie, who's also present, go ahead and state your name. Very Labadie. So, he can solve this judge.
He keeps. What's this under Hyder or what?
Yes, sir.
Okay, let me just check something here. All right, your name?
I'll get you in.
All right, Mr. Gamber, I'm sorry, your appearance again?
Yes, Judge. Tim Gamber, P78192, on behalf of Mr. Labadie.
All right, so he's charged with window peeping at the resident's address.
What?
Yeah.
116 High Clark Court.
Is that a thing?
All right, and he's going to plead guilty to that, and that's going to be under the Homes Youthful Trainee Act?
That's correct, Judge.
It's different than
Is that
window
what you
shopping.
wanna do?
I'm pretty sure.
Yeah.
So if you plead guilty to this, I'm going to place you on probation. I'm going to refer you for a pre-sentence report. You're going to come back. I'm going to place you on probation. The possible penalties here are up to 500 fines, 93 days jail costs, or all those.
You have issues, sir.
I'll defer the proceedings, set terms and conditions, and if you're compliant, the case will be dismissed. Do you understand? I can't hear a word you just said.
Yes.
Did you sign the advice of rights? You didn't sign it. I got to have you guys are killing me. It's just, I'm going to take a 5-minute recess, everybody. Stay seated, please. Why you guys, Laney, Charles Laney.
Are you calling us, Judge?
Yeah, Charles Lester Laney, 25W839-812, 25W839-811A.
Morning, Judge.
Hang on one second. I got to find all the cases here. B and C. Name? I'm not excited about this at all, Mr. Gaith. I'm going to adjourn it to February 4th. There will be no more adjournments. February 4th, give me a trial date. That's going to be a bench trial, Heather. And I will be happy to do that. I took the waiver of the jury trial already, right?
Yeah.
February 4th.
Do you want to do that at 11 o'clock, Judge?
That's perfect. February 4th at 11. Do not ask me for another adjournment, though, okay? That's it. February 4th at 11. You can go down the hall, sir, and you will get your new notice. Anything else? Thanks a lot.
Judge, up.
People
that day
against,
doesn't work. Never mind.
I'm going to take a recess. Stay seated, everybody.
Judge goes out to recess break. He tells everyone else to stay seated. That way he gets first dibs on the monkey bars. Wow. Susie, you've got to go back almost an hour now to see that, or maybe about an hour. Verdict music and everything. You missed it.
So,
Who had you call her?
who had you called? What's your name? What's what I saying?
Charlie.
Did he call your face or anything?
Let's jump to Judge Simpson.
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Kouri Richins'
April
hearing
5th,
begins in about 2
2025,
hours.
at the location of
We hope
South
to be able to
State
go to
Street
that
near
live.
East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Correct. Yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
So I drank a shot of tequila and a shot of aloe. Shot was what it was called. I'm not really
That's
sure.
the
what it is.
sunscreen stuff. Aloe?
Okay, were you stopped by the police or was there an accident?
It was an accident.
What happened?
So on April 5th at approximately 12:30, I was leaving Lucas substation.
She's reading the report.
I had consumed the 2 shots that we discussed, and I failed to stop at a red light at the street of State Street and East Michigan Avenue and hit another vehicle.
Okay, did the police arrive?
Were there injuries?
Yes, Your Honor.
All right, were you ultimately arrested?
Yes, Your Honor.
And were you ultimately taken to the hospital for a
Pepsi,
blood
not
draw?
a sponsor, Mr. Conrad.
Yes, I was taken to the station first and then taken to the hospital.
For a blood draw, correct?
Correct.
And were the results of that blood draw 0.117?
Yes, Your Honor, correct.
2 shots.
Okay, do you have any reason to dispute those blood test results?
No, Your Honor. I believe last trial or the pre-trial, we discussed the difference between the BAC on a ticket versus the blood draw.
Okay,
Sure.
but you don't have a reason to dispute those blood test results of a 0.117, do you?
No, I do not.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if I accept your plea and you commit misconduct between the time that I accept your plea and the time of sentencing, that first of all, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which would lead to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation or to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
At 9 a.m.
February 11, 2026, 9 a.m. Bond with its conditions will continue. Do I have probation intake? I do. All right. And ma'am, I'll ask you to wait on the line. We're going to put you into a breakout room with my probation department so we can begin the sentencing process. Okay?
Thank you. Thank you, Your Honor. Happy New Year.
Thank you. And to you. Court does call the cases of the people versus Devontae Connor Belcher.
When Your Honor, Raymond Cook for the people.
5 cases.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Connor Belcher for one of those cases.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Connor Belcher in the other 4 cases.
Devontae's got
Sir,
his
can
head
you
down.
please state your name?
Devontae Connor Belcher.
Thank you, sir. All right, what are we doing?
Your Honor, we're here for a series of cases, and we're going to be working to get Mr. Connor Belcher into like a recovery court or a drug court program.
All right.
And so we're hoping for an adjournment for a couple of weeks to get that process started.
Okay, do you think you can get, is he held on anything else other than these? Or?
There's a PCC tomorrow for retail fraud in the first degree before, Your Honor.
Okay, so he's held, okay. So how much time are you going to need on?
2 weeks to get started. February 4th day is fine as well, Your Honor.
That is all correct,
Agreed?
Your Honor. Yes.
All right. I'll adjourn all of these matters into February 4th. 2026, 9 a.m. Bond will continue. Thank you.
You guys.
Thank you.
My girl Angie, member for 32
Court calls
months.
the
Oh,
cases of the
gee.
people versus Christopher Dale Chambers.
Back to work after 15 days vacation. It's gonna feel like you started a new job. That's awesome.
Their arraignments without
2 weeks off. What'd you do? Did you
Dale
do something
Chambers.
fun? Or just relax for
Christopher Dale Chambers. No response. I'll issue orders to show cause on both of these matters for the defendant's failure to appear. Court does call the case People versus Brandon Davis.
Relax and home improvement. Good stuff. Good stuff. Sometimes that's better than going somewhere. Mr. Siller's all excited about something.
Brandon Davis.
Hearing nothing. Bench warrant to issue.
Might be Motorola. Brandon Davis.
Yes, I'm here.
All right. What's your name?
Brandon Hezekiah Davis.
Thank you.
Thank you, Your Honor. I'm requesting an adjournment. Mr. Davis' license is still suspended, so I'm asking for more time for him to work on that.
How close is he to?
I don't think it was overly close. I don't have his driver record,
Hang on. Sincere Godwin?
but I think he's paying off some stuff and needs more time. It's
Didn't we see Sincere before? Wasn't that the day we saw the girlfriend? That name looks really familiar.
It's only date after the 4th.
February.
During the matter, you're gonna have to figure out what you're gonna do on this because he's got to show some significant progress. I'll adjourn it to February 18th, 2026, 9 a.m. Bond continue. Or calls the cases of the people versus Matthew Wallace.
Conrad Solar on behalf of Pittsfield Township.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Wallace. Mr. Wallace, state your name for the record, please.
Matthew Wallace.
Mr. Wallace.
Your Honor,
Buttons all
Mr.
the way
Wallace
down to
has
his
a couple
belly.
of cases in circuit court that we're kind of waiting to be resolved. His next court date there is not until February 4th. So I'm asking for an adjournment of these cases. Those are kind of driving the bus here.
They're okay.
I have no objection to a date before then to see if something moves. But he's not. His next pre-trial is not until February.
The pre-trials on February 4th aren't until the afternoon.
Right.
Right. So he'd be, if I set it for the 4th,
he'd be here.
Call before it.
Yeah.
Okay. And those cases are holding him, really.
Yes.
Yeah.
Yeah.
And there's another felony up for probable conference next week.
Hey, Mr. Conrad. Welcome.
That is
New
true.
felony.
It was a new case, older date of offense, but
A new case that's coming before me for PCC.
yeah, I think it's
Next week.
scheduled not this Thursday, but
The 15th. The 15th.
15.
January
Yeah.
15th. Yeah.
and I think that's obviously going to probably follow the
with the, okay.
Yeah.
All right. So let's do this.
If he is, I think he's faking it.
I'll
He
adjourn
doesn't-
it
he
to
doesn't look
then
sincere.
February 18th, which will be my next date after the 4th, 2026 at 9. I'll adjourn both of these to that date. If something, because I think I have bonds on these cases just so that he's getting credit. But if something occurs, let us know. If he's going to be released on everything except these cases, let us know so that we.
I do think he has released his, I failed to mention this, he has released the treatments on those other cases. And
on
the everything else, there's one coming to Your Honor today for these cases as well. Mr. Cook and I discussed it prior to the hearing. I think these may be the last ones that needed one. So he may be released to treatment before then as well. I forgot about that piece.
Got it. Okay. So, okay. I'll sign those orders. They're coming on these two.
Right.
Got it. Okay. That makes sense. All right.
Thank you.
Thank you.
Yeah, so I think these are the last.
All All right, Mr.
Court does call the
Sincere.
case of the people versus Kouri Davis.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Davis.
Who?
She's there, yeah.
Where is she?
Miss Davis?
Oh. Yeah. Ms. Davis?
Yes, my name is Kamaria Davis.
All right, I'll need a camera on you, please. She just muted. And I need your camera turned on, ma'am.
She muted her mic instead.
Ms. Davis, there should be a little camera with a line through it. You gotta click that.
I think we had this problem with her last time as well. Because I remember that name.
People don't know how to work Zoom. We're going to stop letting them appear that way.
I think that's what you said last time, Judge.
Ms. Davis, is there a problem?
You're muted, Miss Davis. Miss Davis, unmute. She is now gone. I will call her up at the end if she's not here. Unless she'll bench warrant, hold it to the end of the day. She'll need to present herself in person to the court. Court does call the case of People versus Michelle Campbell.
All you had to do was turn on your camera. Instead, you ended up with a bench warrant. That's terrible.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Campbell. Ms. Campbell, state your name for the record, please.
Michelle Campbell.
Oh, man.
I have before me a plea form that indicates that the defendant would be pleading to the charge in case ending in 1259.
Mr.
Will
Khan.
be pleading no
Life in
contest
San
to the charge
Francisco.
of retail fraud second, a 1-year offense. Upon her successful plea to that charge,
trying to take my
the other
job.
case, which is up for today,
The whole headphones in the
the
corner
case
bit.
ending in 0533 would be dismissed. That's the court's understanding of the.
Yes.
That is accurate, Your Honor. I believe there was some indication that restitution be reserved for dismissed accounts.
Okay, so what should have been put on here is she's going to pay restitution on all counts. Is there an agreement to that?
There is, Your Honor.
Miss Davis is back. Camera's on. She's up for a recall.
Yeah, have her sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the whole truth and nothing but the truth so help you God?
Yes.
State your name, please.
Michelle Campbell.
All right, Ms. Campbell, it's this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the second degree. Is that
Yes.
correct? That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand that?
Yes.
And that the fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine.
Yes.
You understand all that? You understand what a no contest plea is?
Not really, Your Honor.
Okay.
This is my first time.
No, it's okay. But you don't understand what a no contest plea is?
Not really.
Okay.
I would like to understand.
Have you talked to your attorney about
A
that?
little bit.
Pardon?
A little bit yesterday.
A little bit yesterday, but you still need
attorney's
more
dying
time to.
I would like to.
Okay, let's listen. If I pass this case and the attorney can get back and talk to you, you think you'll be able to have a conversation to see if you understand what you're doing?
Yes.
Okay, so what I'm gonna do is I'll hold the files, we'll pass it. And when you go back and talk to her about what she's actually doing.
Sounds
Okay?
good. Thank you, Your Honor.
Thank you.
Miss Davis, the recall.
Court calls the case, People versus, is it Okas Michael Russell?
Morning, Your Honor.
Yes, Your Honor.
Hold on. Hold on a second. Why?
Mike Elkins?
All right, everybody thinks I'm mispronouncing names. That the way this reads is he has the longest first name known to mankind. And then I'm looking at the screen and it's just Mike. Do you see it?
No, yes, Your Honor, I do see it, and it looks like they.
That is all wrong.
They corrected it, but didn't give you a new sticker. But I got you.
Judge works
I
off the
got you.
sticker. Got a new sticker for the judge.
See, and everybody was going to blame me. I want it clear on the record, this is not my fault. And Mr. Elkins, I apologize for them doing this to you and me.
That's no problem, Your Honor. I got two middle names, so it's been an interesting time with that.
Okay. Court does call the case. Other people versus Michael Elkins.
This is Public Defender Navin Pate on behalf of Mr. Elkins. Please state your name for the court.
Michael Elkins.
See, told you. All right, what do we do?
We're actually requesting as well, frankly, lengthiest adjournment the court would allow. We look to have some issues that he's trying to about Indiana DMV. A lot of it has to do with some payments he needs to be making down there. That being said,
Indiana.
Yeah. Great place.
Is it?
I don't know.
They got a good football team. That's all I know about now. Got a good football team, but that's like a blind squirrel finding a nut. It just happened. So how much time?
As long as the court would give us, to be honest with you. We're going to try to see if we can make progress within the amount of time he would give us for an adjournment. And if not, I would then be talking to Mr. Cook about a potential.
About something. Okay. Why don't I adjourn this out to February 18th, 2026, 9 a.m. And bond will continue. Okay, Mr. Elkins?
Thank you, Your Honor.
All right, thank you.
Thank you.
And I apologize to all my good friends in Indiana. Alan made me say that. I believe in the Hoosiers. Court calls the case, People versus April Fleming.
April's back. These are all the same.
Good morning,
appearances.
Assistant Public Defender Lauren Perry on behalf of
Hopefully
Ms.
she's
Fleming.
doing
Ms. Fleming,
well.
state your name for the record, please.
Ms. Fleming.
Thank you.
You're looking
You know,
better.
this is an adjourned date for the bond violation. We did file a release and treatment order that the court signed. The jail has that. We're just waiting for Ms. Fleming to be assessed, which hasn't taken place yet, but we're hoping now that everyone's back from the holidays, we'll be done soon.
Oh, okay. All right. So you want me to put it out till the 4th and see?
Yeah, I think
see where we are.
We'll probably have some movement.
Okay.
Before then.
Before then.
She was the one that was huffing.
During the matter, February 4th, 2026, 9 a.m. On
camera.
Thank you, ma'am.
Thank you.
Court calls the case, the People versus Sincere Godwin.
Okay, Sincere, here we go.
Good morning. Lauren Perry on behalf of Mr. Godwin. State your name for the record, Sincere.
Sincere Godwin.
Your Honor, we are asking for, I hope will be our last adjournment. Mr. Godwin and I spoke. He just wants to watch the media. There's a ton of media on this case.
Media? Video?
That's
Walmart
why
video?
we're asking for an adjournment.
A video?
Video, yeah.
There's a ton. I don't know how much that is of video.
It's a lot.
What did he do?
Okay.
A ton is.
So if I go to the 18th, you guys think you can get that done? Can he watch all that ton of video by that time?
I think, yes, I'm sure.
All right. Sir, I'm going to adjourn your case to February 18th, 2026, 9 a.m. All right, sir?
Okay. Thank you, Your Honor.
All right.
What
Thank
did he
you.
do?
Sure.
Court does call the cases of the People versus John Hart.
Anybody able to?
Good morning, Assistant
to
Public
get the
Defender Lauren
details
Perry on
on,
behalf of Mr. Hart.
Sincere.
State your name for the record.
John Joseph Hart.
Kamaria has her hand
Your Honor,
over the
we are
camera.
requesting an adjournment of the trials. Mr. Hart will be seeing Your Honor tomorrow for PCCs. I think he has 3 cases scheduled for tomorrow.
Three
Yes.
cases?
So we're kind of waiting to see what happens on those.
Got it.
And Mr. Hart would like me to provide the court with an update. He's been very busy while in custody preparing to eventually be released. He is completing the Beyond Barriers class. He is doing Dawn Farm in the jail. He has been in touch with Dawn Farm about transitional housing when he's released from jail. Okay. He's also obtained a job for when he is released. And he's doing AA every day in the jail as well. So he wanted the court to know all the good things that he's doing. He's really taking, using this time well, and I'm going to get all this information to the people too. So when negotiations occur, that can be used, but he wanted the court to know all of that as well.
Okay. And on the housing issue, I don't know if he had a voucher or not, or is going to need the Rising Hope program. I think I've mentioned it to council, and just I don't know their entire procedure, but if he needs to get on a list or can get on a list or something like that, then
hey Kevin,
that may help with the housing aspect.
The hat might need to
If
go.
I may, sir, I
go ahead.
appreciate your input.
Your input.
The transitional housing at Dawn Farms, I signed up for that already.
Okay.
I did transitional before years ago. I think Mr. Allen was around when I did it. Officer Allen, yeah, he
Hold on a
knows.
second. How long ago was that?
I have.
How long ago was that with Allen?
Yeah, he's been around.
He's been around?
Believe me.
That's what I've always said about him. I said Allen's been around.
Oh yeah.
Yeah.
Believe me.
Okay,
He
go
knows,
ahead.
he knows what he knows. Okay.
Well, I know,
Yeah.
right?
Yes, sir. Yes, sir. But I do have the Alcoholics Anonymous. I have the Dawn Farm intake, the group guidelines and expectations. And I have a letter for you, but I do appreciate your input, and I want to do this right this time.
Okay.
When I did it back in the day, I wasn't
back
it
in
wasn't
the
his
day.
fault. It was if it was his fault, it wasn't of his own. It was mine. But I know what to do now.
You know what to do now?
I want to get rid of these. I want to get beyond the barriers.
Got it.
That's what I'm trying to do, sir. And I appreciate your input and your understanding.
He brought,
Okay,
he
very
brought
good,
that same
sir.
prop last time. He said beyond the barriers.
Back
last
around
time.
back in the day. I know, right?
Thank
Okay, thank you,
Assault.
Bon.
I appreciate you.
Take care.
Mr. Allen smiling. Assault or assault and battery for sincere.
Did I give a date?
There's a lot of
I did
video.
not. I was so fascinated by Alan. I wrote it February 4th.
Greeners, thanks for the text. I got the text on the case.
Alan, back in the day. Wow.
Been around the block.
I know, he's been around. That's what he said. We'll talk about that. All right, no, I'm with you. Corco's Gate, people versus Wilmer Hudson.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Hudson. State your name for the record, please, sir.
Wilmer Hudson.
Thank you, sir.
Your name
You
request.
know Alan?
Yeah.
Okay. All right.
I do.
I'm just gonna find out. I'm gonna find out everybody that knows Alan.
And we play basketball a lot.
Oh, is that right? Was that back in the day?
Back in the day.
Okay.
Yeah.
Wow. All right.
I'm telling the truth.
No, I know you are. The three of us are just finding this all out.
Yeah, he's always been quiet. He's been a quiet guy.
No, really not.
Yes.
No.
He has.
Then you got the wrong Alan. You.
He's been quiet. I'm for real.
No.
Always quiet.
No.
Never gave you
Dude.
problems.
No, you need to see that man back there in chambers. All right, go ahead.
Your Honor, Mr. Hudson and I are still in communication about what he wants to do, so I'm just asking for a brief adjournment. I think the 4th will be okay if that's
Will
okay.
it work? Okay. I'll adjourn the matter February 4th, 2026, 9 a.m. Bond will continue.
Thank you.
Thank you. I didn't know that. Well, they say
It's all
reminiscent.
It's all a good mood, but this could
Quiet
snap really
machine
quickly.
time. Court calls the case People versus Trevor Howard. That's what's called karma.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Howard. Mr. Howard, state your name for the record, please.
I'm not going to ask. Go ahead.
Your Honor, we're requesting an adjournment of this pretrial for plea negotiations.
Okay.
Mr. Howard wants me to address bond. The news I have for you is that I did speak with Mr. Cook. There's
It's
new
not gonna
cases
happen.
that are going to be arraigned.
Nothing's happening.
So I think what would be best, Mr. Howard, if I may, is we keep that bond motion until we know what's happening with those new cases.
His own lawyer doesn't want to address
Just to
bonds.
get the lay of.
And that would be correct because I wouldn't change anything knowing that there's new cases until I can see what all of that is.
Yeah, I
Simpson
don't
gets
know
really
if
spicy.
they're scheduled for arraignment, but I will get in touch with the magistrate and see if we can get that done ASAP.
Mr. Cook, do you have any news on the other?
So new charges were authorized yesterday, so I don't believe they've been set for arraignment yet. The
Got it.
charges that were authorized are for fleeing and eluding in the third degree, 2 counts of that, the felonies, as well as a couple of misdemeanors.
Okay. So let's do this and see if we can get it all in and sort of wrapped. I'll adjourn this to February 4th, 2026, 9 a.m. Don't put a diplomatic date on it. Okay.
Thank you.
All right. Thank you. Court calls the case People versus Francis Judge.
And this is Public Defender Natalie Pate with on behalf of Mr. Judge, who stands to my right. Please state your name for the record, sir.
Francis Judge. Thank you, sir. All right. What are we doing?
Thank you, Your Honor. Ultimately, I'm requesting an adjournment. Mr. Judge and I were just able to connect today this morning, and he now has my contact information. He will be going to be making an appointment with the Secretary of State to see exactly what he needs to do to get his license valid. He believes that there was some sort of judgment that he paid up, and he just needs to confirm some things, and I need to also look at his driving record. So I'd be asking for an adjournment sometime into
Oh,
February.
you think it might be suspended because of a civil judgment?
That financial obligation.
Yes.
They
Got it.
I appreciate you postponed 3 times for me, but I wasn't able to pay it. I finally was
You
able.
finally did get that?
Yeah.
Okay, and so now you gotta figure that out. Okay. So what I will do, so let me, just so that we're clear, the financial responsibility, you say you paid that?
It's paid, and
Okay.
the Secretary of State's got the paperwork. They sent it to them.
Okay, because if the Secretary of State has it somehow or another, if that's the only thing,
Then I'd be able to go get my.
then, yeah, well, my record's still,
I have-
my record's still showing, okay.
I have right here.
Okay, but I'm just gonna say my record indicates it's still suspended, which would usually change if it's where he's got to get a new license, because, okay, I could see this. So at some point, the license that he had will have expired in 2023.
Yes.
So even if he's clear, even if my record still indicates suspended, it probably isn't suspended. He probably needs to go back and he needs to get his license reissued.
But this right
Yes,
here is the financial obligation paperwork that you wanted me to.
I believe you. Who's here with you?
My mother.
Your mom? I believe your mom. I don't, you were iffy, but I believe her when she handed it to you. All right.
And yeah, if I may, Ryan, that does make sense, because I believe he states that he has his state ID, or he may
Got
have
it.
his ID now. So yes, he would need to go to Secretary of State to get his actual license.
So you can get that done by the 4th, or you want me to give you to the 18th of February?
I gotta make an appointment with the Secretary of State. I'm sure I can get it done by then.
Well, let's do this. February 18th, 2026, 9 a.m. give you some time to get the appointment, see what you got to do. If you got to take care of other things and do it. Okay.
Thank you, Your Honor.
Thank you,
Appreciate
sir.
you.
Thank you, Your Honor.
I'm an alum of IU.
Pardon?
I'm an alum of IU. Football team.
Yes.
First ever.
Well, it's a good team. I mean, a lot of people didn't believe it, and you watch them, and I have to say, they're for real. All right, take care. See, when he said he was an alum of IU, I was gonna go, hoo. But court calls the case. People versus Kawandaki Thomas.
Morning, Your Honor, Raymond with the people.
Well, no what?
And Assistant Public Defender Natalie Pate with it on behalf of Ms. Thomas, who's saying to my right. Please state your name for the record, ma'am.
Keep on Clay, Cynthia Rose Thomas.
Thank you.
Thank you. Thank you, Your Honor. I'm asking to set this case for final settlement conference. I have had the opportunity to discuss it with my client.
Okay, was this the one you said we had other cases?
Yes. I think I counted
8. When are they up?
for sentencing next week.
Okay.
Yeah. Oh my God, I'm lying.
What? And you're aware of that?
Oh, the sentencing's next week, Your Honor? Yes, Your Honor. And she does have a release to treatment that Your Honor signed on this case, as well as her felony cases.
Counsel approach.
Yes, Your Honor.
To a whole retail price.
Cindy, 6 months on the jury. Thank you very much. Congratulations. Y'all make me so happy. We're just happy you're here, Cindy. Wouldn't be the same without you. Judge has gone sidebar. Judge McNally's mad about something right now. I'm not sure what it is. Can we jump to it? Let me see what it is.
No, I know this was my case. She took it in my absence. I don't know where I was on that day, but she took it in my absence. I get it. I'm not quarreling with that. But I was I'm not voting on who's going to be accepted into Judge Hessen's sobriety court or not. And I was told this was her case. I don't remember this. I mean, if I was that good at remembering every face that came in front of me on every case that I ever handled, I have no business being here. I should have been present. Give me a break. Here's what I'm doing.
He's mad.
What's that?
He was referred for your sobriety court on the new case.
I know that.
Okay.
But I've never talked to the man. I didn't take his plea. I never saw him at a status review. The email sent out said that it was Judge Hessen's, and I wasn't going to vote on it since it was Judge Hessen's case. Here's what I'm doing. I need to back up on this. I'm not doing anything right now. I'm going to adjourn the sentencing for a couple of weeks, and I'm going to take a look at everything. I didn't even read anything on this because I did not believe it to be my case. So I will adjourn this 2 weeks. I'll adjourn the sentencing. Are you here on the 21st? Well, I'm not here. Heather, I need you to give me another date, please, for a sentencing.
That'll be February 4th at 9 o'clock.
Sorry, I got to go all the way to February 4th at 9 a.m. But I just do. I didn't even read the report. I don't even remember seeing this blue back in my file today. Maybe.
That I will say, because of bond violation, I brought it down to say this morning. So
Yes.
I will say,
So
all new stuff.
but
I didn't see the report.
I understand the confusion of the email.
I'm putting this back. That's what I'm doing. He's to remain, and then I'll decide when I talk to the other people in you or whoever else. I'll decide what I'm going to do on this, but I can't. You're going to have to go down the hall and get another date, sir. I'm sorry.
Fair enough.
You understand? All right. Thank you.
Thank you.
Johnny Thornsberry.
Okay.
Where's Johnny Lee Thornsberry?
We're going to switch back. New case for Judge Simpson. What you got?
Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. Kiesling. State your name for the record, please.
Shannon Marie Kiesling.
Thank you.
Your Honor, we are requesting adjournment for negotiations.
So what were you doing all the other times? No. Just thought I'd.
Well, we were.
No, I don't need an answer. I know you were.
We were going down one route and now we're kind of going down a different route. So, your Cook and I will be in touch.
I don't know what that means, but will the fourth be enough time?
I think so. Yeah.
Well, if it's not gonna, tell me.
Well,
Talk to me, Verity.
I won't be here, Judge. So
I know you won't. That's why I'm wondering if it gets shifted to someone else. Is that going to cause a problem?
Oh my God. I'm like, is Mr. Brown listening?
Brown listening? Is he here?
I don't know.
I don't feel. Hold it. I don't feel confusion in the air, so probably not. What?
Simpsons.
Not right now.
I meant that as a compliment.
Yeah. Wait. You could say something. You could say.
I can set it for the 4th or the 18th.
Your Honor,
No, you two go ahead.
Can I speak to you?
I don't.
Your Honor.
Can you go ahead? What do you want to tell me?
I'm waiting. I've been here. Things have been postponed, but in all this time, I've been doing AA every day.
Good job.
Either in person or online. I'm also doing school. I'm taking a business management class.
Awesome.
Okay.
Staying with my mom. I have the tether. Obviously, I've had that for 5 months. So I just had my 5 months sober.
Nice.
And I've not been happier in 3 years. I drank for 3 years. It wasn't a lifelong thing. I was in a really bad relationship and it was just drinking. And that's how I got into the DUIs. I'm the happiest now I've been in 3 years since I'm away from that.
So Brandon can do that.
He's in jail and I don't ever want to drink again. That's how I feel. So I just feel like I'm really improving my life. Really, all my kids are proud of me. I've got my family back. They all support me. Yeah, I just wanted to get that out there.
No, that's
thank you.
Who's here with you?
And he's in jail.
My sister.
Your sister.
From Florida.
From Florida. So that's one of the ones that came back to you once you stopped drinking.
What's that?
That's one of the ones that came back to you once you start drinking, that you found part of your family.
Yes, and my children. We had Christmas and it was, oh my God. Yeah, my whole family back.
That's cool.
Mm-hmm.
That's fantastic to hear.
Yeah.
We're still going to.
Ms. Giesling always has a family member here with her. It's very
nice.
I do.
Yeah, no, I remember, but they're different times.
The first time he thought my son was going to be coming up here. I'm like, no, it's me.
Yeah. Okay. And so, well, that's, it's always great to hear. And probably, I would imagine for the last 3 years, certainly, Christmas wasn't Christmas. And then you got that back too, and you had a good.
I did. Well, I got rid of a bad person in my life and got the good people back.
And sometimes when you're drinking, you can't tell the difference, right?
What's that?
Sometimes when you're drinking, you can't tell the difference.
Exactly.
Between who's really on your side and who's not.
No. Yeah.
And you get in a situation where you're almost afraid to move. But then once you do, you see that there's a good life out there.
Yeah. And I'm free of that person. He's in jail, so I'm all good now.
Yeah, that seemed to make you smile more than being.
Yeah.
I'm just saying. I'm just telling you what I observed.
I can do all the good things,
All right.
Sobriety and the ex is in jail. That's
all right. So how much time would you like to? Because you got to try to.
I know. Let's go to the 4th. I think I'll have a conversation with Mr. Cook. We had a conversation this morning. I think we can make some progress here.
You think so?
Yeah.
Well, Mr. Cook isn't letting you make progress?
Oh, no.
Is he standing in your way?
He's hitting the ground running, making progress all the time.
Okay. All right. What I will do is I'll adjourn it to February 4th, 2025. 9 a.m. Both of these matters.
So, I'll give us
2026, if I didn't say that right. 9 a.m. The bond will continue, and it's I'm glad you took the opportunity to say something to us. It always makes me feel good to hear those kinds of things.
Thank you for listening.
You're welcome.
Have a good day.
And welcome from Florida.
Right? Why would you come here?
You got to be enjoying the weather here. Yeah. See, the fact that she's up here with her sister from Florida, that's love. All right. Okay.
Thank you.
You guys take care. Court recalls the case, People versus Jamonte Love.
Morning again, Your Honor. Raymond People.
Good morning again, Your Honor. Shauna Bassi on behalf of Jamonte Love. Mr. Love, please state your name for the record.
Jamonte Love.
All right. I now have before me a plea form signed by the parties that indicate that he's going to be pleading to count 2, guilty to operating while visibly impaired. The 93-day misdemeanor. Upon his plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's correct, Your Honor.
Correct, Your Honor.
All right. So, Love, can you raise your right hand, please, sir? There you are. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record, please, sir.
Jamonte Love.
All right. You can put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor, punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. Do you understand all of that, sir?
About 2 hours back.
Yes, Your Honor.
All right. And understanding all of that, you still wish to plead guilty?
Yes.
All right. And sir, to that charge, how do you plead?
Guilty.
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had caused an advice of rights form to be signed. Is that correct?
Yes, sir.
Do you have any questions regarding any of those rights?
No.
You understand that you're giving up the rights on that form, is particularly the rights contained under paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here to get you to plead to this charge?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty?
Yes.
What'd you do?
June 1st, 2025, at the location of Munger Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, you consumed intoxicating liquor?
Yes.
What'd you drink and how much?
What did you have and how much?
I had 2 beers and a Long Island.
Were you stopped by the police or was there an accident?
Stopped by the police.
The police.
Why'd they stop you?
Drunk driving.
My wife and I had a big disagreement, and I was pulling out the driveway to go to my parents' house just to diffuse the situation. And
so the police had been called for some other matter. You were leaving and they stopped.
Yeah.
Okay. You're not disputing the right of the police to stop you in this case, sir, are you?
No.
All right. Were you then ultimately arrested?
Yes.
Were you taken to the police station or into a hospital?
To the hospital
well, you were
first.
taken to the hospital for a blood draw. Is that correct?
Yeah. Yeah.
Okay.
2 beers and a Long Island.
And
what was the percentage?
was the result of that blood draw for alcohol a 0.129?
Sounds about right.
Yes.
All right. And it also showed that contained in your system was THC or its derivatives. Is that correct?
Yes.
Are you disputing the the blood test results, sir?
No.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to the consumption of alcohol?
No, I was good to drive. I was good.
Yes.
That's the right answer.
Sir, I have to advise you that if I accept your plea, between the time of my accepting your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
All right, and have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be February 11th, 2026, 9 a.m. Bond will continue. Sir, I'll need you to wait on the line. I'm going to put you into a breakout room with probation intake or my probation department so we can start the sentencing process, okay?
Your Honor.
Yes, ma'am.
Thank you. Mr. Love is asking the court if they would be agreeable to allow him to travel out of state for his son's track meet to Louisville, Kentucky from January 7th to the 19th.
Hold
No,
on.
that's February.
Son's track meet.
I'm sorry, February.
That's February.
Son's track meet in February what?
17th to the 19th.
17th.
Through the 19th.
Correct.
Yes, sir.
It's his son? What's he run?
My son and daughter. My son is 12. He runs the 200, the 400, and 60-meter hurdles. And he's a national champion, so we're trying to qualify for the Adidas Nationals in March.
Sounds like he's good.
He's really good.
He's really good?
Yes, sir.
Did he get that from you?
Yes, my family. And he's also
he goes, I can't run, but my family
no,
can
I
run.
can run.
I know.
He won
Any
Junior
objection?
Olympics last year.
Oh, pardon?
He won the Junior Olympics last year for the 100-meter hurdles.
Did he?
Yes,
really?
sir.
And he's from Michigan?
Yes, sir.
See, good things always come from Michigan. All right. So he's going to go down to Louisville and show them, huh?
We're going to do our best to, yes.
I'm more confident than his daddy. I think he's gonna run the table. That's all right. Here's what I'll do. Defendant may travel, of course, to and you said to Kentucky, correct?
Correct.
And that was 17th through the 19th. That includes your travel time, sir?
Yes, we will leave Saturday afternoon after his solo concert and band, and then we come back Monday morning.
And he plays band too?
Yes, sir.
You know, I hear about kids like this, and I probably should have done something in high school. But anyway, all right. 17th. All right. So it all indicate February 17th through the February 19th, 2026. All right. I will permit that travel. All right.
Your Honor,
yes,
one other thing. Mr. Love is requesting of the court that he be removed from the sober link, as this was an isolated incident and it is a financial burden on his family.
I understand that. I'm not going to remove it, and certainly wouldn't remove it until I see an evaluation, in which time he'll shortly be set for sentencing afterward. So that request I'll deny.
Thank you, Your Honor.
At this time. All right, thank you. And sorry, I don't know your son, but just
Good luck.
tell him on behalf of a proud Michigander and this judge, I wish him the best of luck, and that I have faith that it's all going to be great. He's going to bring home gold. All right.
I appreciate that, but I messed up on the dates. My dates was January 17th, not February.
That's what your counsel said first, and then you corrected
Yeah,
it.
I was looking at my calendar. I'm looking at in front of me. I was looking at the wrong dates, but I'm sorry about that.
See, he would have missed the track meet. He would have been down there in Kentucky just wandering around. Nobody, and you need to get it together. Okay, it's January 17th through the 19th. All right.
Thank you, Your Honor.
All right, take care.
Have a good rest of your day. Thank you.
You do the same.
Thank you.
It's just both files.
Are they, okay. Court recalls the cases of Michelle Campbell.
Morning again, Your Honor. For the people.
Good morning. Assistant Public Defender Lauren Perny on behalf of Ms. Campbell. State your name again for the record, please, ma'am.
Michelle Campbell.
All right. And Ms. Campbell, we were at the point we had sworn you in. I told you what it said on the form you're going to be pleading to and how you're going to be pleading, and that was a no contest plea.
Yes.
I got to the point of asking you, did you know what a no contest plea was? You remember all that?
Yes.
And thank you for letting me know that you weren't really sure of that.
Thank you.
Okay. Did you get an opportunity to speak with your attorney?
Yes, I did.
Okay. So I'll ask you again, do you understand what a no contest plea is?
Yes, I do.
All right. Two important things about a no contest plea I have to make sure that you understand. And that you understand that it, first of all, means that you're not desirous or wanting to contest this charge of the retail fraud second. You understand that?
Yes.
All right. The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Taking a nap.
All right. Do you have any other questions regarding a no contest plea?
No, I don't.
All right. Basis for the no contest plea, Ms. Berman.
Lack of recollection.
All right. Ma'am, to that charge of retail fraud second degree, how do you plead?
No contest.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
Understand.
All right. Now you signed an advice of rights form or had your attorney sign an advice of rights form on your behalf. Is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that you'll be giving up those rights, particularly the rights in paragraph 5 that are on the podium. You see that?
Yes. Barely. I don't have my eyeglasses.
Okay, but you understand that you're giving up the rights that were on the form
Yes.
and that your attorney explained to you. You understand you're giving up your right to appeal of right.
Yes.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. The court has been provided and has reviewed Pittsfield Township Department of
Tampa's
Public
working
Safety
on a
report for
hangnail.
their case number 21-14925. Any objection to the court having reviewed that report?
No, Your Honor.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of no contest to the charge contained in the case ending in 1259. Yes, that's right. And case ending in 0533, that is dismissed pursuant to that plea agreement. Defendant is referred to probation. for pre-sentence investigation and report. Sentencing in this matter will be January 28th, 2026, 12 noon. All right. Bond will continue. Thank you, ma'am.
Thank you.
Court recalls the case People versus Kouri Davis.
Oh, she's back. She's back.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Davis. Ms. Davis, state your name for the record, please.
Kouri Davis.
We are requesting adjournment to review the media. Mr. Cook and I had a discussion today about surveillance footage. I think that's our officer on our way.
Removing everything but the cuticle.
During the matter to February 4th, 2026, 9 a.m. Bond continue.
This is 11. I just moved it up.
You just moved it up. Okay.
Yeah.
Let me take a brief break. Let everybody get where they are. I'm done with investigation.
Yes, sir.
All right. Court's in recess.
All right. Time about you can go back to consuming fingernails. It was yucky. Yeah, she was hiding. I don't like that courts let people do that, where they just. Hey, Joy, welcome. Tampa's like, I'm putting my hat back on. If he leaves, I'm wearing my hat. Hat has seen better days. It's a little worn on the bill.
This is the Kinyarwanda interpreter.
Hey, Joy.
Do you need a Kinyarwanda interpreter?
Kinyarwanda? Wow. I don't even know that language exists. Kinyarwanda?
Maria.
Hello.
Kamaria. What? It might be Tamba. Thomas getting out of the car. He's waited too long. All right, we're going to be getting set to go over to the Kouri Richins hearing, which may start. It's supposed to be on detectives. I don't know what the long shot is. Who's the long shot? Is that somebody in chat? I've seen it in a couple of your messages. I don't know what the long shot is. Is that somebody's chat name that I'm missing? Not seeing it. Detective, it's every time you say something, it adds the long shot to it. That's not me chatting, says Detective Vids. What? Someone's taking over chat in Detective Vid's name. Weird. That's suspicious. This is weird. You might... Now would be a good time to change all your passwords from a different computer, a brand new computer that you've never surfed the internet on. Call your bank, make sure everything's fine. You're being... See, this one's fine, but this one is not. Let's see. Oh, the long shot says, what's going on here? I'm the long shot 910, and I think I might be the one causing some confusion. Okay, so it's even funnier. The long shot 910 is posting as Detective Vids, and Detective Vids is over here saying, it's not me. Do you have something on your clipboard? No. Okay, this makes sense. This is the long shot 910 having YouTube think that long shot 910 is Detective Vids. These are the best. These are the best errors ever. We've been incepted. Yes, I would request the long shot 910. What I'd suggest you do is close your browser down all the way, reopen it. Please come back. Do come back. We'd love to have you post under your own name in chat. But I mean, you've got Orange Courthouse by your name here as long as you're Detective Vids, which is cool. So I would restart it. I think YouTube's just YouTube's just got confused with itself. This is crazy. Tinfoil hats on. I was confused as to why TechVids kept saying the long shot. All good here. Thanks for checking in. Seriously, the long shot 910. Close down your browser, log out of YouTube, log back in, and it should fix it. YouTube is drunk. Go home, YouTube. You're drunk. Yes. I missed milestone. Paula Mack, I'm sorry I missed your milestone. Hold on just 1 second. Let's see if I can find it. Boom. 32 months right here. I miss listening and being in chat. Currently training 3 new employees in the office. So ready to be back home working remote. I love our addicts. Paula Mack. 3 new, it's like herding cats at that point. 3 new employees. Congratulations, OG. Let's see. Is there a plea in the not relevant case at 11:30 or the NR case? What's NR? Who's the NR case? We're going to jump to Judge Dad while we wait.
Team, stop doing this.
What?
Have them fill
Yes,
out
sir.
a petition for court-appointed lawyer, detective. Thank you.
Now we need to
Thank
back
you,
up.
Honor. Thank you, Your Honor.
We need to back up just a little bit and see what just happened.
And he also has 25G306-414.
A little more.
King Jr., 25G306.
Oh, here we go.
414, 21T636-962A and B. And can you get that last one done for me, Mr. Crawford?
Yes, so I can find.
Okay.
What? I don't know. I think that was the last
Didn't you have another drunk driving or something?
one. Oh, that was, yeah.
Okay. Your appearance?
So Judge McNally
Gerald King Jr.
is mad and Judge Simpson is happy.
Your name, sir? Your
Gerald King Jr. Sorry, sir.
Detective, your name?
Detective Corporal Sean Pontiac, Trent Police Department.
For purposes of arraignment, he has 21T636-962A, B, and C. He doesn't show up in court. And he also has 25G306-414. Does he stand mute, wait formal reading?
Yes.
Well, he's another one that's going to end up with a bond. And then people will say, well, the judge locked somebody up on a suspend. What do they want us to do when the guys repeatedly don't show up? And then they tell us stories. I mean, he's missed multiple times on these cases. 1, 2, 3, 4, at least 3 or 4 times on these cases. So I hope you got some money with you, Mr. King. Hope you've enjoyed playing fugitive. Where does he work? How much does he make?
It's not working right now. He was picked up going to the job.
Picked up going to a job interview. Where was the job interview?
At Walmart in Dearborn off Southfield Road, sir.
Huh.
In front of the Walmart.
I don't know what to tell you. It's bad.
In front of the Walmart.
I don't know what to tell you. Did Redford turn him over to you guys? I mean, Dearborn turn him over to you guys, Corporal?
Your Honor, I believe he was stopped in Riverview, and Riverview turned him over to us.
Why were you telling me you were going to Dearborn Walmart? You live in Redford, right?
Yes, but I stay on Riverview, Michigan 19470, and that's where I was coming from. Riverview, Green Trees Apartments off 4th Street, sir.
I'm not sure I understand. How could you get Okay. Anything else?
Judge, that's about his previous criminal history. Apparently, it's kind of in a slump there. Right, 2015. So he did a few months in paper saying of unsuccessful completed probation. He hasn't had any serious criminal offenses since, other than just the traffic violation.
You don't show up. Judges can't give personal bonds. Pass it around when you're down there at Dickerson or wherever they take you, okay? 3,010% on 962 A, B, and C combined. 2,010% on 306-414. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. The earliest date I can give you, I'll give you tomorrow. I'll be more fair with you than you have been with us, okay? That'll be January 8th at 10 o'clock in the morning. You're all right with that, aren't you? Us being
Absolutely,
more fair
sir.
with you, us being more fair with you than you have been with us?
Yes,
You're
sir.
okay with that, right? I mean, you don't want me to treat you like you treated us, are you? Do you? Or else I'd set this for next July.
No,
Right?
sir. Thank you, sir. Yes, sir.
How old are you?
I just turned 36, sir, and just got married.
Quit acting like you're 14. Stop doing this. Have them fill
Yes,
out
sir.
a petition for court-appointed lawyer, detective. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Mr. Polk, do I have a case with Mr. Polk? He keeps popping his head in.
No, I just put him in a breakout room.
Does he have a case with me?
He does. I told him he had to file his appearance. He said he thought he filed it. It's with Wells.
What kind of case is that?
That one is operating with a high BAC, it looks like, Judge. I just finally threw him in there because I've had an attorney and a client in with York for quite a while, and Mr. Polk's been waiting, so I finally just threw him in there.
Is that the last case, the one with Mr. Polk? Do you know, Heather?
No, there's another one that's been in with Mr. Urick for a while for Ciccatelli, and that's Attorney Puda in there with them.
All right. What time? Yeah. What time were those cases scheduled, out of curiosity?
Wells was for 10:15, and 10:30 was Ciccatelli. Well, I said they've been in there for quite a while, so finally I just threw Mr. Polk in there instead of waiting any longer.
All right, good enough. Thank you.
You're welcome.
Detect Vids, you might have something on your computer that's causing this problem. I'm just looking. Longshot 910, clearly a bot. Very AI type responses. But it looks like it's being generated from your account, which could be a problem. You might have something on your computer. I would suggest closing your browser, going out, and restarting your browser, coming back, maybe even using a different browser to come in. You don't recognize Longshot 910 in any way as any other account you've had or anything else? Okay. Hang on. Hold, please. I'm going to see if I can get YouTube involved, because if it's a bot, we need it banned.
Yes. Yes.
It's a good idea. Detect Vids. I recommend that. Log out and then log back in. But you might want to use a different device. Your computer may have a problem. Yeah, the AI hype it's unbelievably high. It sets off my AI radar in a big way. Detectives, you might also want to try to log into a different channel and see if it does the same thing there. That would be an indication that the bot is an infection on your computer and is causing problems. Just being the tech guy I am, if you are infected, it may be too late to take some steps. And some steps you take are ineffective because the bot already can see what you're doing. Yeah. Every time it says long shot 910, I'm going to, here's what I'll do on my side. I'm going to just block that. So no comments will show up with that in it. Because if that's a real person, they haven't been taking our advice on how to fix it, and we can ban them from the channel that way. So give me just a second. Okay. Let's see if that works. Add to our banned word list. What's with the conference room? Who's in the conference room down the bottom with the view? The white desk and white chairs. Clearly, that's a lawyer's office. And just like that, he's gone. He's gone. It's possible that DetectivVids is also just offline right now. So kid with his parents in the conference room? Possibly. All right. Now that we think we've sorted that out, it's a weird bot. I'm just checking it, trying to look online to see if that's shown up somewhere else to learn what kind of infection that is. Let me ask Grok. Let me ask AI if it knows what that is. Hold on one second.
John, I have those files ready.
Yeah, it's a bot. Could also be a hacked YouTube account, which could be more problematic because DetectVids is a YouTube content creator as well, and his account was showing 0 subscribers shortly a while ago. So that's a concern. All right. Third State Judicial, Webster and Regier is up. We're also getting close to Kouri Richins starting. So, yeah. Did we solve the mission? Not sure. We blocked it from vision. Like it, not even our mods see the comments now because they automatically are deleted before they make it to the screen. Let's see. So hold, please. Let's see. Let's go here for a second. Burnett Circuit Court. Where were we going?
And do you agree with and accept all of those conditions as they have been laid out by Attorney Schieffer?
Yes.
Do you have any questions as it relates to what the Child Support Agency and Attorney Schieffer are?
Yeah, we're not gonna do child support stuff. Sounds like family court. We don't go there. Okay, let's keep this prepped. And now start that and go here. All right, we were going to go to, 33rd in Kansas? Let's see what we have. Judge McBurney has some stuff going on. Hold, please. There she is. Let's go here.
And then the clerk heard you had been in custody, but the jail did not appear and you did not appear. Then I understood that you had a separate case of 25 CR 457 that is not on the docket today. And it, I think, was a felony, which I don't take. We set a bond for 2,500. Did you post that bond?
No, I haven't yet, Your Honor.
All right, so you still have, that's what my concern was. You still have that warrant out.
Your Honor,
Mr. Regier?
give my interjection, but I am showing that on October 10th, 2025, a professional surety bond in the amount of 2,500 was executed for today's date and time.
Well, my notes do show October 9th, order warrant, bench warrant, and then I show October 13, return of service, but I don't believe I have a copy of any bond. So, Deputy, can you track down the bond if there is one? You have a copy of the bond, Mr. Regier?
I got a copy of one right here.
All
It's
right. Well, I don't see one. Oh, wait, it's popped up here, October 7. It's popped up today. Strike that.
okay. You did post that.
Okay. All right. So, Ms. Pickles, this is your first appearance on one count of driving on July the 1st of 2025 without proof of insurance. This is a B misdemeanor. If convicted, you could have a sentence up to 6 months in jail, probation an option. You would have to have a fine, the minimum which required by law is $300, the maximum being $1,000. You do have the right to an attorney. You can hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply for court appointed and see if you qualify. Or you can waive attorney and represent yourself. How do you wish to proceed on the issue of an attorney?
I'll take a court-appointed one, I suppose. I don't have any money to pay a lawyer.
All right. Why don't you, Deputy, why don't you go ahead and give her an application to fill out while she's here? Give that back to the deputy before you leave. You're not employed at this time, Miss Pickards?
No, I'm retired.
And do you have any kind of retirement income?
I get a widow benefit. I'm so
And-
far behind though.
Okay. Fill out that application and,
Your Honor,
yes, Mr. Regier.
for what it's worth, I'm not sure if this has any bearing on the court's orders from today, but in 25 CR 457, it would appear that an order appointing private counsel or public defender was filed with the court on October 6th of 2025. That order does appear to be with respect to Attorney Shannon Cooper.
And which judge, was that in the felony case that was appointed?
That is the state's information, Your Honor. It would appear that the last two settings were previously before Chief Judge Rickey.
All right.
Mr. Gear helps out
Chief
there.
Judge Rickey has determined that you qualify for court appointed. I'm in his felony case. I'm pretty confident that you will
doing
apply
makeup.
in this
You
misdemeanor
on a hill.
case. Fill out the application. I will tentatively appoint Darren Patterson, but I need to confirm that. Mr. Patterson's office is across the street, but let me get that application back from you this morning. You can leave it with the deputy and maybe I don't know, clerk, if you want to file that and file or what you want to do. But go over and give Mr. Patterson your contact information. This is tentative. If I get that application and it doesn't comport with what you're telling me or with what you told Judge Rickey, then you may lose the appointment. But it sounds like we'll probably appoint Darren Patterson. So when is the next date for Mr. Patterson, please, Jenna?
I can't hear.
I'm sorry, did you say you couldn't hear me? Who couldn't hear
Yeah,
me?
it was cutting out. Sorry.
Okay. Well, I asked the clerk when the next court date for you would be.
Your Honor, I'm sorry. I had another technical error and lost everything you said. I caught that you needed a date.
Now the judge is muted.
I'm so sorry, Your Honor. It's still crashing on me. Give me just a quick second. You were needing a date on a Darren Patterson Monday morning?
Yes, please.
Okay, March 23rd, please.
All right, Deputy, will you give Miss Pickards that date? March 23rd, 9 a.m. She will need to be back here.
Kouri Richins is probably noon.
Don't you?
I do. I wanted
About 15
at 8
minutes.
a.m. I wanted to go across the street, and this is a continuance in her request and the added condition to her bond that already has been posted. Did you get any or all of that?
Not at all.
Yes.
Not at all. All right, thank you.
Thank
Anything
you.
further? Mr. Regier, anything further?
Kouri has a
Court is
2-day
continuing the
hearing.
bond in this matter. The state has nothing further, Your Honor.
Continuing the bond.
Then go
All right.
across.
Why won't they let me explain why I have my insurance?
Yeah, Mr. Patterson can help you with that.
Okay. Gotcha. Thank you.
You're welcome. Thank you. You may go. All right, Deputy, who else do you have?
Last name Rose. Kelly Rose.
Thank you.
You bet.
We got some troubles and stuff. That's
Kelly coming. Hi.
Good morning.
Good morning. Are you Kelly Sue Rose?
I am, ma'am.
Very well. We are on the record in BU 2024 TR 3219, State of Kansas versus Kelly Sue Rose. Jared Regier for the state. Defendant Miss Rose appears in person and pro se. Miss Rose, you failed to appear January 22nd, 25 at the time I had set for first appearance. It looks like you called November 18th of 25, wanting to pay your fine and get your driver's license reinstated. And you were correctly told by the clerk that you need to come to court today, which you have done.
Yes, ma'am.
So let's go over what brings you here today. It's basically a citation you were issued December 4th of the year 2024 for operating a motor vehicle without legal registration or with an expired tag. This is an unclassified misdemeanor. If convicted, your fine could be up to $1,000. Your sentence could be 30 days to 6 months, although probation is an option. You might qualify for diversion. Did you hear about diversion when I talked to the group about it earlier?
No, ma'am.
Okay,
My car was overheating on the way here. I got here a little bit after 9. I missed that little.
okay.
Hang
You
on.
do have the
Car
right
was
to an
overheating?
attorney. Do you want to hire an attorney, apply for court appointed, or waive attorney and represent
She was
yourself?
driving?
I'll just waive attorney and take care of it today if I can.
All right. Well, you understand that you have the right to an attorney if you want one. You can hire, and if you can't afford, you can apply. You understand that?
Yes, ma'am.
Is anyone making you give up your right to an attorney today?
No, ma'am.
All right. The officer has a form for you, a waiver of counsel form to sign.
Okay.
Please read that over. If you have any trouble reading it, let the officer know and we can make sure you get help.
Read right there, sign right there.
Read and sign. Might be
That's the
12:30
date.
Eastern for Richins.
We'll take care of that.
Okay.
Yeah. You
So
read
we
it?
know it's on
Yeah.
delay.
Okay. Read and sign, Judge.
Okay.
Thank
I have my registration from that incident. I got my registration on 1/15. And then I got my new registration for this year.
2016.
Yeah, but I can't find the piece of paper, but I did take a picture of my license plate
Judge
with
has a power
the
mug.
white sticker, silver sticker, whatever it is now. So I
Well,
have a picture.
Since you've gotten your license or your tag reinstated, what you might be interested in is the county attorney's diversion program. Have you ever had a diversion before? You don't look
no,
like you
I'm
know.
not. No,
Okay.
I don't know what that is.
Well, it's a contract that you enter into with the county attorney that if you get your registration in order, which you've already done, you pay your fine and costs plus the diversion fee, and whatever else they tell you, they will just, when you do that, they will dismiss the charge and keep it off your record. Are you interested in looking into that to see if it's something you want to do?
How much is the
No,
fine?
I don't think I care if it's on my record or expired registration. It's not the worst thing in the world.
All right.
It's not going to
I
keep
don't
me
want
from
the
getting
fine.
bonded or anything like that.
All right. Sounds like you've looked into that and decided it's not an issue for you.
Just like,
Is that
no,
right?
put it on my record.
Yes,
I'm good
ma'am.
with that.
All right then, Ms. Rose,
That's
how do
funny.
you want to plead to the sole count before you today or before the court today?
Guilty.
Operating a motor vehicle without registration or with expired tag on December 4th of the year 2024.
Guilty. I was operating my vehicle without tags.
All right, and the citation says this happened at 15,000 Southwest Butler Road South in Butler County. Does that sound right?
Yeah, on the roundabout right there, right near the roundabout.
Okay. And you were driving a 2014 Chevy Cruze, is that correct?
Yes, ma'am.
Regier is going to show no
All right.
mercy.
And is anyone making you enter this plea of guilty today by any threats or promises?
No, ma'am.
You understand that with this plea, you're giving up your right to trial. You will most likely be convicted and unable to appeal your conviction.
Yes, ma'am.
Do you have any questions for me about anything I've said so far?
No, after this, I do have one question. After this, will I be able to go to the DMV and get my license?
Well, that's up to DMV. I don't have control over DMV.
I mean, will I get a piece of paper here that says I've been here and dealt with this?
You can get a copy of the
drove
journal
here.
entry as soon as it's available, yes.
Oh, no.
Okay, how does the DMV know when I take care of things?
You tell
The
them.
clerk is very good about sending them notices of what happens down here.
Oh, okay, it goes through the computer. I forget it's modern
She was late
times.
because her car overheated.
Well, I don't know if they send it through an old-fashioned mail or if they do it by computer, but I think they do it by computer modern times, like you said.
Okay.
But the clerk knows all that. Okay. So you still want to maintain your guilty plea to this charge?
Well, yeah, I was guilty. I was driving, but I did get my registration and everything fixed. Yeah, sorry.
Okay, well, I find that you are knowingly and voluntarily entering this guilty plea and that you've given me a factual basis to it. I find you guilty.
Prosecutor.
Recommendations for sentencing from the state, Mr. Regier.
Yes, Your Honor. In this matter, the state is recommending that the court impose a $100 fine, court costs. The state has no objection to a non-reporting probation of 6 months. However, the state is recommending the maximum time permitted by law for this particular offense of 6 months. Pursuant to the ticket, it would appear that according to the court comp statute, the registration had been expired for over a year at the time of the stop. It would also on the issue of disposition, it would appear that the court comments refers to a prior stop within approximately 1 month by another jurisdiction.
So she knew.
All right. Anything you want to say, Miss Rose, before I determine your sentence? You don't have to, but you're welcome to if you want.
Yeah, I didn't. I had purchased the car when I moved here in June of 2022, I guess it was.
Deputy
No,
can't help you.
23. And I purchased the car and I thought that they were going to send me the registration on it and they didn't. And then I got the ticket on from Woodlawn, and he told me to go take care of that. And before I could take care of it, I got the other ticket in Rose Hill. So I didn't realize that they weren't going to send me anything.
Okay, so when Mr. Regier mentioned the ticket in the other jurisdiction, that would have been either Wichita Municipal Court or Sedgwick County District Court? The prior one? Woodlawn is inside of Wichita, Sedgwick County.
Okay, so what do I do about that one?
Oh, you probably still have a
That's not in my
warrant.
jurisdiction. You better talk to your attorney or
have a warrant
prosecutor
from
over
the other
there, but I don't
Call the
know.
number on the thing, call the number over there and see if what I do. Because I just want to go in there. I just want to pay the money. I'm moving and I don't want to I just want to get my license and move.
If you keep driving with a suspended license,
my niece drove me here today.
Okay,
okay, because you could end up doing some mandatory jail time if you get caught again, so be careful.
Yeah.
And by the way,
My
be
niece,
careful.
my niece is
don't
out there
violate the
waiting.
law. I don't
Yeah,
mean
I
go
went-
out there and dodge the officers. I mean, don't violate any law.
Yeah, my niece drove me today. I'm not doing anything.
Good for you and good for your niece. All right, at this time, Miss Rose, your fine is $100. Your court costs are $108. The total due is $208. Can you pay that today or do you need some time?
Yes, ma'am. I'll pay it on my way out or wherever I go.
Okay, now I was told by the clerk that they're having some system errors or system issues. You have to pay the exact amount. Can you do that in cash? Go across the street if necessary? Okay.
Oh, and I can't use my Cash App card?
I
There's
don't
a bank
know.
card and a Cash App.
They're down right now.
Yeah, their systems are down. But there is a bank right across from the courthouse at the end of that block.
Oh, okay. That's fine.
And they might be able to help you get some cash.
Or an ATM machine somewhere,
Yeah,
right?
yeah. Well, they'll have an ATM machine too.
But you need to
can
bring in
use
the
your
exact number of pennies.
Oh, awesome. Okay, not a problem then.
You'll see it. There's I think it's a credit union. There's a bank a block from it. Financial institutions around. Yeah.
Cash
Okay,
App,
no
not a
problem.
sponsor.
Not a problem.
All right. So I'm going to order that you pay that by the close of business today. I'm going to give you a sentence. Your sentence is 6 months in the county jail. If you don't want to serve that jail time, make sure you're successful on a 6-month non-reporting probation. You will not have to see a probation officer, but you will be on probation starting now for 6 months from today.
What does
The
a probation entail? I've never been in trouble
All
before.
right, I'll work through that with you. You do what I tell you are your probation conditions, or
You've been
up
in
to
trouble,
6
you just
months from
didn't
now can
address
get
it.
revoked and you can go serve your jail sentence. What the probation entails to keep from getting it revoked and serve your jail sentence are just a couple of conditions. The first one is don't violate any laws during the 6-month probation. The second is pay the $208 today. So as long as you don't get any more violations of the law and you pay today, your probation will be satisfied at the end of 6 months and you won't have to worry about getting it revoked.
Okay, awesome.
Okay. Anything further, Mr. Regier?
From the state, Your Honor.
Now, does she need to be processed? She came in on a B misdemeanor today, so go ahead and process her, deputy, but she won't have to pay a bond.
Your Honor, if I may.
Mr. Regier?
Your Honor, this is a case where it would appear there was a prior failure to appear and an appearance bond was filed with the court on December 30th. For purposes of the record, the state's information is that count 1 is charged as an unclassified misdemeanor. However, for this particular offense, there are certain special sentencing provisions pursuant to KSA 8149.
Okay, but since she posted that bond on October 14th for failing to appear, I don't need to get her reprocessed, agreed?
Yeah, based off of the record, that would appear accurate, Your Honor.
All right, what was the special sentencing provisions? Did you think I needed to do something else?
Nothing further from the state, merely acknowledging that pursuant to KSA 8149, although count 1 is charged an unclassified misdemeanor, that same statute does authorize, quote, imprisonment in the county jail for not less than 30 days nor more than 6 months.
All right, so again, don't get in any more trouble.
I will.
All right, thank you. You may go at this time, Miss Rose.
Yeah.
Thank you.
You're
Okay, I have one more. Hopefully that will be it.
Hello? Hello?
Good afternoon. This is Brian Econo with the Healthcare Marketplace. How are you doing today, Tingit?
Mm-hmm.
Well, the reason of my call is that you already have your health insurance from the marketplace, right?
I have those.
Sorry?
I have.
And have you received your updated cards and benefits for 2026?
Do I need to speak slower for you? I can't tell if you can hear me. I'm sorry. I hate that script. I hate that script. The reason for my call is you already have this. Is that a question? Rewrite the script. Sorry. I almost got cussed out again. Healthcare Marketplace, the Medicare scammers. Yes, that was them. That was them. We are waiting, awaiting. We are waiting and awaiting the Kouri Richins hearing to begin. The judge has ordered it to be delayed on the broadcast. So hold tight for that. It is not the trial itself. It is it's scheduled for a 2-day hearing, basically one of the last hearings before the trial begins. And it might deal with some of the issues about what can come up, maybe some lemonade, motions in lemonade, as we like to say. So excited about that because it's going to be a very interesting trial. And yeah, we're not doing Uvalde. We're not following that case at all. If you're disappointed by that, I apologize. That's my choice. I'm not doing that case. It's just too hard with all the child victims. It's just a difficult thing for our community to handle. It gets like soul-suckingly depressing to go through some of the facts. It did get a little spicy. I think there was possibly mistrial type stuff happening. There's been a delay. It's been, yeah. Anyway. Ready for the trial to begin. I'm sick of the Richins shenanigans. Well, we'll see. We'll see how it goes down. There's also a possibility, a very slim possibility, that the au pair case does not go south. And you know what I mean when I'm talking about that. If it doesn't go south, we might pick that up and watch that a little bit. But we've got some other stuff as well that's all starting. If you're interested in Uvalde, Ian Runkle's doing recaps of the trial. Awesome. I think that's great. Ian will do a great job on that one. And highly recommend his channel as well. Uvalde is having a hearing today about the potential Brady violation. Yes, there was that yesterday where the prosecutor had some new information from a witness that the defense had never seen before, and that is a Brady violation. And it could actually end in mistrial. The whole thing could blow up before it begins. We have to start over. So Isn't there a trial starting next week? There are several trials. There are several trials starting right now. So we're going to have too much to watch very soon. But all right. Let's see. That's Kouri. Judge Webster is done. Let me jump back over here. Judge Simpson is still up and live.
At this time.
You're dismissing?
Yes, no objection from me or my client.
Your client doesn't object? You want your case dismissed, Mr. Phillips?
Yes.
Yes, sir.
Dismiss you and your beanie.
Case is dismissed. Take care of yourself.
Thank you, you too.
That's called the case of the People versus Carl Rogers.
Good afternoon, Your Honor.
It's a Brady violation.
Yes, Public Defender Natalie Pate on behalf of Mr. Rogers. Should be on Zoom.
Yes.
There he is. Sir, can you please state your name for the court?
How you doing? My name is Carl Rogers.
Thank you.
Thank
What's up,
you, Your
man?
Honor. I'm asking for a brief adjournment.
You need
I
to
have
put your
been
chain
able to
away.
speak to Mr. Rogers briefly before the last pre-trial. Yesterday, we weren't able to touch base. I ask for a brief-
February 4th, 2026, 9 a.m. Bond continued. Thank you, sir. Court does call the case. People versus, is it Erika Scott?
Erica.
And Assistant Public Defender Natalie Pate with on behalf of Ms. Erica Scott, who is.
Is it pronounced Erica?
Live from
Correct.
the
What's your
gym.
name,
Scott.
Live from the
It's
gym.
pronounced Erica.
Correct.
Everybody's trying to mess me up with these spellings and names.
I'm here in my sports bra. Let's get this thing started.
This morning, she did email over some documentation that I will provide to the people, so I'm asking for a brief adjournment.
Okay, go ahead.
So the documentation she sent me has to do with the proof of insurance charge. As far as her license goes, she is still suspended, so I need to talk to Mr. Cook about that further.
And I'm just wondering, is she gonna try to get that clear before we?
She is, but if that's not, she may be, Your Honor. That's not our ultimate goal.
At this, okay. Well, let me do this. I'll adjourn this to February 18th in case you want to head down that path, give you time. 9 a.m. bond will continue.
Thank you, Your Honor.
All right. Thank you, ma'am.
Thank you.
All right. And I'll forget how to pronounce your name by the time you come back. So,
Okay.
all right. All right. You take care.
Thank you to the silence.
She gone. Judge is like, I'm done. I'm done. What do you want from me?
Court does call the case. I'm sorry. Court calls the case. People versus Russell Smith.
Good afternoon, Your Honor.
I'm gonna leave that. I'm gonna leave Alan alone. Russell Smith. And here, this time a bench warrant will issue. Bond 5,000, 10%. That warrant will issue immediately. There you go. Court calls the case People versus David Stevenson White.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mr. Stevenson White. Mr. Stevenson White, state your name for the record, please.
David Stevenson White.
Thank you.
Yeah, so the court may remember Mr. Stevenson White is currently in recovery court.
Yes.
Once he completes recovery court, he can go pay his reinstatement fee. He's still wrapping up the program. Do you know when your graduation date is, Mr. Stevenson White?
Not at all. I cannot say, but I'm very close. I believe I only have maybe less than 2 months. I actually have court tomorrow. Because I'm doing good in the program. I only go to court once a month now.
Got it. And you think you're 2 months out?
Yes, because I have to reach I forgot to read my paper, but I think phase 5 is only a maximum of 4 months. And I've been on for, it feel like almost 4 months already for sure.
All right. Let's do
Feels
this
like
way.
10.
Give me my first date, March. March 4th, that's what I thought. All right, so what I'm going to do is I'm going to adjourn your case to March 4th, 2026, 9 a.m. Before you come back, if you're not off, we need to know what your date would be so that I can set it so we can get this all resolved for you, all right?
Okay, definitely. I got court tomorrow with Judge Slay at 10:30, so I'll get a lot more information.
She's good.
All right. Are you going to actually talk to Judge Slay?
Yes. Yep. I'll go in for
All
another.
right. So if she doesn't give you information, what you do is you tell her you were just before Judge Simpson. He told me, give me my information.
Yeah.
No, don't tell her that. Don't do that. Don't do that, man. All right. All right. Just get that information. You'll be good. Okay.
All righty.
Thank you. Take care. Court calls the case of the people versus Tenyata Thomas.
Good afternoon, Ayden Cook of the people.
Oh, there she is.
And Assistant Public Defender Natalie Pate on behalf of Ms. Thomas, who's present via Zoom. Ma'am, can you please state your name for the court?
Danaya Thomas.
Danaya. See? It doesn't matter. It doesn't matter how I pronounce somebody's name today. I'm going to mess it up.
Thank you, Your Honor. There will be a resolution at the next pretrial. That being said, I did just get the plea form today, and because Ms. Thomas is on Zoom, I need to review it with her. But it is an offer I did previously discuss with her that she wants to accept. It is to plead guilty under HIDA to the charge with an agreement to pay the restitution amount. So we're just asking for a brief adjournment so I can get the paperwork in.
February 4th, 2026, 9 a.m. All right?
All right. Thank you.
Thank you. Take care. Court calls case of the people versus Kevin Trejo Galindo.
Good afternoon, Ayden.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Trejo Galindo. Your Honor, you should have a plea form. Mr. Trejo Galindo is going to be pleading as charged.
Counsel approach.
Give me a second here. All right. Let's see if we can jump to Kouri Richins. Hold, please. All right. Give me just 1 second to get everything sorted the way I need it. Let's get 4. Is 4 cropped? 4 is 100%. 3 is 100%.
All right. Did he say his name?
Alrighty. Hold, please.
Good morning, Your Honor. Brad Bloodworth, Margaret Olson, Lindsay Shervanack, and Fred Burmester for the state.
Very good. For the defense.
Wendy Lewis, Catherine Nestor, and Alexander Ramos for the defense.
All right. Counsel, as I understand it, we're here today to address the defendant's motions to exclude 3 of the state's experts. Is that correct, Ms. Lewis?
Yes, Your Honor.
The states recently filed a motion to exclude one of the defendant's experts not on the list for today. We'll address that in some fashion in the future. Yes?
Yes, sir.
Okay. Ms. Lewis, do you have a plan on how you want to proceed?
Your Honor.
This is a preliminary matter. My apologies.
Just thank you, Your Honor.
Of course.
This is Kouri Richins with her new attorneys. This guy is off the case last year, I think.
Your Honor, the state wants to ask the court to make additional findings in connection with its order from yesterday denying the state's motion to determine admissibility of evidence. The court's findings regarding the defendant's financial crimes as it relates to the state's pecuniary gain element argument is clear.
Pecuniary?
In its briefing, the state
Pecuniary?
raised 2 additional arguments that the state asks the court to address. The first is that the defendant caused Eric Richins' death to cover up her financial crimes, and this proves an additional motive as well as the identity and intent elements. And the second argument is that the defendant's...
I'm sorry, no, I just am having trouble hearing. I need you to pull down the mic. Thank you.
And the second argument, Your Honor, is that the defendant's financial crimes show that causing Eric Richins' death was her last resort, and this proves the identity and intent elements. The state asks that the court make intrinsic evidence findings on these two arguments and additional findings under Rule 404, as these additional arguments increase the probative, in the state's view, increase the probative value of the financial crimes evidence. Finally, Your Honor, regarding footnote 3 of the court's ruling, the state asks that the court note that the state advanced its complete the story argument in its moving papers before Blackwing issued, and then in its reply papers revised its argument to comport with Blackwing. Thank you, sir.
Yeah, let me be clear. I understood your arguments. I just didn't find them persuasive. The state simply hasn't carried its burden to show a sufficient or persuasive basis that the arguments you just described satisfy the legal standard for intrinsic, or provide a sufficient or persuasive basis to avoid the court's view of the balancing of the propensity inference that is most likely to be drawn under 404B, which implicates the 403 analysis the court made.
Your Honor, I appreciate that.
Wow.
And I don't think
I heard
that
they were
comes
just bad
through
arguments.
in the ruling. I think the ruling very clearly and specifically addresses the pecuniary gain, and the court, may have built in its thinking as to the other two of the state's arguments, but I don't know that that is reflected in the ruling, and I think it would help if it was.
Okay. I understand your position.
Okay. Thank you, sir.
Anything else on a preliminary basis?
No, Your Honor.
Okay. Very good.
Very good.
Ms. Lewis, my
Good try,
apologies.
but no.
No, it's okay. You can sit down. Oh, go ahead.
Your Honor, I did want to ask, can I move in and out of the courtroom as business requires?
Out of the well? Or out of the courtroom?
Both.
Yes, that's fine.
Thank you, sir.
Thank you.
And walk in and out.
Ms. Lewis, we're here to talk about 3 experts. Happy to handle those in any particular order. Happy to have some legal argument and colloquy before or after taking testimony if necessary. What's your view of what the defense needs to do today?
Well, we're handling different experts, but if we could maybe handle Ms. Ayden and Dr. Fox first. I think that if Ms. Ayden were to testify and then Dr. Fox, and then we could handle that, and then Kathy, you're doing
the other two.
And then Ms. Nestor's doing the other two, so I don't know.
Ms. Nestor, where have we seen her before?
So either order on the others.
High-profile forgive me, with respect to Dr. Fox, nobody's challenged her.
No, she's going to testify if the court needs to hear it about the scientific reliability of the pathway to violence and why it should be excluded as under 702. Based on her
Let's talk about that structurally. Okay. If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than admissibility?
Well, possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on Ms. Ayden first.
May I just briefly address the court?
Sure.
Then
take
Ms.
your questions.
Will address Ayden.
Okay.
Your Honor, because
put the mic back down.
It's the state's belief that the defense has not even met its minimal requirements under Rule 12.
To do what?
The challenge?
They specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the papers sufficiently address the threshold showing. As the court is well aware, after Ramash, after cases like Clopton and Gun-Hildary and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through, it sort of flipped it upside down, so it catches almost anything. And even if there's two witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers, the state believes it has met its burden of a threshold showing. Now, the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other two are on the line. So, if the court wishes to proceed on to specific questions about Ms. Ammon, then Ms. Shervinack can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each witness's testimony. So the state's argument regarding the insufficiency of the defendant's initial briefing is respectfully rejected. I have specific questions regarding each witness. Within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. So whose witness is Ms. Ammon?
This is deep in the political weeds. Or not political, but the legal weeds.
You just got to pull that mic closer to you. Okay.
Buckle up, ma'am.
In its brief, in opposition to the defendant's motion to exclude Ms. Ammon's testimony,
defense is trying to exclude a witness.
Occasions, and in bold print, the state says Ms. Ammon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Ammon testifying? Is it in the state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me, that in the state's view, Ms. Ammon's testimony may be helpful to the trier of fact to rebut an argument that, hey, this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husbands. And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence, but this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part.
Okay.
I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Ammon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an analytical framework. And again, Ms. Ammon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She will not be saying Ms. Richins, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Amon will not be saying, Miss Richins fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Amon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
sometimes, right?
Well, yes, but also Ms. Amon could describe that in every targeted act of violence, and this is part of her proffer, that there is a framework, a pathway to violence that perpetrators of targeted violence follow. Now, do they complete a couple steps and pause? Do they all follow the same timeline in the exact same sequence? Maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack. And all of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke some questions regarding the Diaz versus United States case that was cited in defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not a implication regarding the defendant's mental state or what was in their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question. I mean,
if she says all,
and she can explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I don't think that's what Ms. Amon's testimony would be, but I would rather not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will?
This is a pre-crime.
Those people exist, and Ms. Amon would not know who those people are.
I read her proffer. She seems to explicitly acknowledge that people stop at various points along the pathway.
That's my point. So to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always, no, that's not her testimony, and that's not factual. But for her to say, in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result. The attack has occurred. We can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay. All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sherman?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point. And
is it cited in your brief?
No, because I didn't know about it.
Okay,
it's something
can you give it to
just
me?
Discovered.
That's okay.
While she's looking that up,
is
the lady next to the woman who's standing,
United States versus
Ms.
Wells.
Nestor.
Let me give you the site.
Is the Charlie Kirk accused shooter lawyer. So she's handling two very high-profile cases in Utah.
879 F3rd 900. And that case was also a blind expert who is actually one of Ms. Amon's colleagues in writing the profile for violence. And his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And there's also, and yeah, I'm sorry, I actually just found this case yesterday. But there's also a 403 and 404B argument because the way this works in courts when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using the precursor to the profile for violence. It has very much the same criteria. It has been modified since then. This was in 2017. And he did a profile of killings in the workplace. He was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z. So therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like, I've looked at Ms. Amon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be missummarizing here. But there's a higher level to it. And when we look at Diaz is even more specific, and somehow a majority of the United States Supreme Court is like, they said most, not all. So the trier of fact can draw distinctions. How do I apply Diaz to Ms. Amon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
That is one you cited.
I know it is, and I did not reread that case. So I would actually
we can we'll take a break at some point.
Need
we
a
can
moment
compare.
to review that, to be frank.
Okay, Ms. Shervanek.
Oh, I'm sorry.
Oh, okay.
I do think that it would be helpful to hear Dr. Fox's testimony. For one thing, this routinely isn't used. It's used in BAU as an investigative technique sometimes, but it's not used in the courtroom. And that's because of all these problems that Dr. Fox is much more qualified to address than I am in terms of it's junk science is what it is. It's not scientific. It's not used in the community.
This is Wendy Lewis.
I think that does stop it, even under our low threshold here.
Well, she's arguing
hold on, but come back to the specific.
Her last high-profile case was Brian David Mitchell.
Of this case, the state has noticed Ms. Amon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness. To the effect of, this is not the way it works.
These are big-time lawyers.
This allegation that Kouri Richins killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Judge flips his argument to the other side and says, argue the other side.
Yeah, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Ayden.
I think we're going to need some clarification beforehand. If Ms. Richins testifies and talks about testifies that she did not do this,
That denies committing the crime.
Then how does that not open the door for them to say, well, of course she committed the crime because she's on this pathway to violence?
No, I don't think they get to do that. That would be more like profiling.
Okay. I still have the whole 702 problem no matter how, and this is the first I've heard it's only going to be used in rebuttal. I think we would actually use less time if we let Dr. Fox
Happy to
go through and explain the problems with the reliability of the science and then go from there, if that's all right.
Sure. Ms. Shervan.
The only points I wanted to make, and the court has honed in on this, but in Dr. Fox's declaration that was submitted as an attachment, she analyzes the federal rule 702 and why Ms. Ayden's proffer does not fit within that. There are fundamental differences between the federal rule and the Utah rule, and I don't believe that it's helpful for the defense's witness to make a legal analysis about whether Ms. Ayden's testimony does or does not comport with Rule 702. That is for the court to do. So
I agree, but I can sort that out.
And Dr. Fox is familiar with the Utah Rule 702 and is prepared to address that.
Well, yeah, but I don't need her to address the law at all. I just need her to tell
really wants Dr. Fox on the stand.
View
I understand, but she hasn't now analyzed it under the Utah law. All right. Would it be all right if we go forward with Dr. Fox?
Sure.
All right.
Dr. Fox, good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can see Ms. Lewis.
Good morning, Dr. Fox.
We might get just a side angle.
Hi, Ms. Lewis.
So could you just please state your name for the record and tell us what your current position is?
This is the defense expert.
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you...
Ms. Nestor comes up.
Did you want to swear her in? We didn't do that.
Yes, thank you.
Thank you.
Dr. Fox, would you please raise your right hand?
Nestor says she's not under oath.
Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tax. I went to the University of Florida to earn my master's, and then I earned my PhD instead of my JD from the University of Cambridge in England. My doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with Reddit assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Ayden, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division, and in between there, I worked with the Tampa field office in the field of investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly, you talked about that you worked with the BSU, and I know Ms. Ayden has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy. That's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over in the research arm. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology, law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
All right. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment through my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts, in a legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then try to help improve the scientific validity of both profiling and threat indicators, is what really has motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessment, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said she isn't.
Okay. Just wanted to make sure as we move forward.
There was no challenge.
All right. So are you familiar with the pathway to violence model?
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right. And is it designed to diagnose or predict whether a specific individual will commit violence?
No.
Again, no. It's a subjective group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. You know, it applies sometimes, but in other cases, it doesn't apply. So we really have no idea how often that occurs. You know, it applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Well, group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's behavioral science unit, the infamous, organized, disorganized profiles, they were created just like by thinking about what we see sometimes in cases, and sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested. You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, but it's one person's opinion. There hasn't been a scientific evaluation of this to actually say, this often it applies, this often it doesn't. There's no known error rate. There's no accuracy rate. There's no reliability measure. It's just a, guess.
So that's why it's important in a legal framework that the pathway to violence is descriptive framework and not predictive. Yeah, it's descriptive. It would be like saying that both of us are female, and females are more prone to, I'm trying to even think of an example that wouldn't, that would be kind of as like detached from the data. But we could say, well, both these women would, engage in, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two, people that, our judges seeing today, both are in a courtroom, that doesn't mean all women are in a courtroom. The example I use in my undergraduate course, every person who went to the moon eats chicken. That doesn't mean that everyone eats chicken goes to the moon. All right. So does the pathway to violence, does it tell us how likely it is that someone will engage in violence?
No, that's a major flaw of it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think the major, I keep on saying this, another major problem I have with this is there are lots of people that have those grievances. I can name so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence. Or they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, out of a larger group and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the pathway to violence model is doing, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on, our thoughts. It's not even based on their analysis of data.
All right. So addressing the reliability and the 702 standards, has the pathway to violence been published in peer-reviewed journals?
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I've researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I'm aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You could write whatever you want as long as the publisher agrees to print it, you're good to go. And Ms. Amon's proffer, the pathway to violence model, was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like mean, but that's a predatory journal. They like write to me often and like ask me if they can publish whatever I want in that journal. It's not like a legitimate, like valid journal. So, and that paper that was published in the Journal of Forensic Sciences, it wasn't even about the pathway to violence model. It was about political assassination in the United States. The pathway to violence model was only mentioned. It wasn't even a study of the pathway to violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
When discussing reliability, why is it important? I asked this, I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, I mean, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that, stamp of approval if it's not reliable and valid. I mean, that's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the pathway to violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody what I determine to be a grievance could be different than what Ms. Ayden thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say, that fits, and there's subjective interpretation behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
All right. So different evaluators could look at the exact same fact pattern and come up with opposite conclusions. Is that fair?
Yes, absolutely, because there is no standardized criteria for what these things mean. They're barely even defined because, again, there's so little peer-reviewed papers
so much shade
discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these side areas. So an example of this would be two evaluators could use the pathway to violence model and can reach opposite conclusions, and there's no way to determine who's correct.
Okay.
This is why they wanted Dr. Fox on the stand.
So is that consistent with things that are admitted as being scientifically reliable?
Yeah, Brianna Fox.
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is if you have two people stand on two scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on two scales at my gym and at my doctor's office and there's two different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day and all of a sudden you're getting different results, it could mean that your weight has changed, but if it's 2 times in the same day, probably not. It means your scale is broken. So, this model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that, and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, inter-rater reliability is basically this idea that if two people use the same construct, will they get the same result? And if people are having the same scale, implementing it, and get different answers, it's not reliable. It just has a basic foundational level. So you would want the same instrument applied and to get similar results. So two people should be able to look at the same case and have a general agreement that this person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect. Inter-rater reliability, that's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the inter-rater reliability on the pathway to violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say I think this person, or, this is what tends to occur on the majority, that somebody would be on this pathway to violence. You have no idea how often that happens. You have no idea how often you're wrong. You could say that is the case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem for in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right.
The whole purpose of this is to get a witness thrown out that the state wants to
Is there
bring.
any scientific data showing how often? I'm almost done, but I'm sorry, what? Oh,
I didn't say anything. My apologies.
oh, okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and without overemphasizing this, there is no reliable data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on the pathway to violence. That was literally the task I had. I was the person who did it. And literally, this was in 2000. The first time I started on it was 2010. And then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I'd been finding, I didn't have the resources to really complete this in the way it should have been done, and it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong, we just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh, it's not based on any data. It's based on, I teach a forensic psychology course, and so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right? But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition, educated guesswork, and hunches. And so I always teach my students, that was the 70s way, but we're doing this differently now. And the Pathways to Violence model was developed in that same approach.
Pathways to Violence was used in the Crumbley's trial.
Okay. So Ms. Ayden, and I suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offense has occurred to then go back and use the Pathway of Violence model?
No, that's like a basic logical fallacy. That was probably on your LSAT exam, that you can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, when
I say it was used in the Crumbley trial, it was
pathways to radicalization. We've toyed around with this idea. They've all been kicked around and kicked down, but that one was the pathways to radicalization profile. And it was this traits shared by attackers. They're young, male, Middle Eastern. And you could say, looking at the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Like literally it goes down from, oh, everybody who, commits terrorist attacks fit this profile to 0.00000, like I don't even know how many digits out, 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalization? There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, oh, all the people fit that. Not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them just without even having 1% accuracy rate.
She's throwing shade.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw. By implying these group level descriptives, you're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. They, go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their, situation. They even may say, "I'm so stressed, I'm mad." They will never go on to commit violence. This is an extremely rare base rate event. And low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, like as an American taxpayer, I feel very concerned by that.
So let me ask you.
In the Crumbly trial, the prosecutors tried to bring it in.
Testified about
kept out.
If Ms. Ayden were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because, if we were that good at predicting violence, think about the problems we have when we're talking about parole. We're talking about, risk assessment, when we're looking at releasing people. We're doing, my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior, because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence. I could actually, look that up in a couple of minutes and tell you what the base rate is. But because this pathway to violence model has never been evaluated, anyone who would say, here's what I think, they're just guessing at how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose, if it doesn't actually
ever predict? They tried to show the parents should have
who
seen that it was going to happen.
Go forward to commit a violent act.
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting, looking at this, putting very sophisticated predictive models together, we are so unable to predict violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than, any type of, long-term grievance, at least based on research. If we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy, because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh, no. And that's actually, again, something I talk about in my undergraduate courses. We have this problem, it's like mission creep. We think, because it applies here, it can apply over here. And that's absolutely not the case. A domestic violence type of scenario, poisoning, or they're so fundamentally different in the way those two things are committed, played out. Applying something that is, even without data, created for the purposes of these targeted attacks that do engage in more radicalization behaviors. You applying that to something that's statistically more emotionally driven, that would be very inappropriate.
All right. So just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence that a jury can rely on?
Big finish.
No, absolutely not. If we're basing this on reliability, if we're basing it on, how using it to know that this is scientifically valid, it absolutely not. The logical fallacies that are endemic to this, the huge amounts of unknowns, like how often it's wrong, which would be far more wrong than right. It's akin to like the Barnum effect at circuses, or like psychics. That would be the closest, I would say, in terms of how accurate and valid and applicable it would be to an individual case.
Barnum and Bailey. It's a circus. All the shade has now been
do you have
thrown.
any questions for Ms. Fox?
I do not.
Ms. Fox, may I ask you just a couple of basic questions?
See where the judge
Sure.
stands.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
No, I wasn't. There are these, similar models, like, I think they call it like pathways to radicalization. And I just learned about that. And again, like while I was in the BSU, that was one of the things that I was brought on to try to revamp and improve.
Okay, thank you. Ms. Lewis, anything further?
No, Your Honor.
Okay. Ms. Shervanek, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
Thank you.
See ya.
Ms. Lewis, do you want to ask any questions of Ms. Ayden?
Are
What?
you not going to put Ms. Ayden? Is the state going to put Ms. Ayden on, or only if I have questions? I guess would be
Ms. Shervanek, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from her.
Okay.
Okay, so the
Ms.
the
Ayden,
opposite
do you mind
expert
turning
into all that. She's
may I
been
swear you,
catching all
please?
that shade.
Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
All right, so now we get the other side of the story. Let's hear if there's a fire
Good morning,
response
Ms. Ayden.
or defense
Good
of
morning.
this model.
Your Honor, before I begin with her testimony, Ms. Ayden's CV lays out her qualifications. The state's position is that she possesses the requisite knowledge, training, experience, education to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I'd prefer to focus my questions directly elsewhere. if that
I
makes sense.
agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor.
The defense did not
So,
object.
Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances.
Like meow?
In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears. They vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. Affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localize sound. And the cats would inch forward. And they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began.
Kouri is laughing.
And
She can't stop laughing.
over the next several decades,
Kouri's
that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger, and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, there was really no time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived. In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did not do that were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI, to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of the studies, many studies. So that's kind of a 10,000-foot view of the science in terms of how we got to where we are
Was
now.
this study funded by Purina?
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m. But what I can tell you is that you're at heightened risk for a cardiac event, and we need to manage your condition with lifestyle changes and probably some medication to lower that risk. That's how we work in behavioral threat assessment, and the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do, we would begin to look at the behaviors the person is demonstrating, and being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure, that is, behaviors that raise for us concern about whether or not violence might be on the horizon.
It's never been used in court before.
Is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, you still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple. Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant. What's relevant is that certain behaviors must occur in most cases in order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Were the cats planning the violence?
Is the pathway to violence model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to a potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation, it's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
And now, if you could explain the retrospective analysis and why prospective analysis is not feasible.
Sure. All the studies on pathway and proximal warning behaviors are retrospective. In fact, someone asked me at a conference the other day, where are we on prospective research? And my answer was nowhere. We can't do it. So retrospective analysis is looking backward at cases with a known result, so violence. So let's say I want to look at a single person homicide in a workplace. I would look backwards at the completed event, knowing that it had the result that I'm interested in, violence, and then I would look for what patterns of behavior can I identify that did occur leading up to the violent event, and then code those. And so I would know that those occurred. So a retrospective study would have a sample of cases and then look backward in time and code the behaviors that we know to have occurred. And that helps us to understand what are the commonalities. You can't Dr. Fox is absolutely correct that those studies can't be used for prediction. They're not predictive validity studies, but what they do is validate the measure as measuring what we intend it to measure. Prospective is you would need a prospective study to truly call something predictive, but to do a prospective study in violence would be to have a case of concern, and then look for what you believe to be pathway behaviors. And once you've identified them, it would require you to sit back and do nothing and allow violence to unfold and then code your data, which is horrible to even think about. None of us would ever do that. So we use retrospective analysis, and it's widely acceptable in the behavioral sciences as a research strategy.
Thank you. Just a moment.
Okay, now, what about in criminal prosecution? It's not widely accepted.
Those are my questions for you at the moment. Thank you, Ms. Ayden.
Does Dr. Fox have any questions for Ms. Ammett? I couldn't find a picture of her. I apologize.
Just a moment. Good morning, Ms. Ayden.
Good morning.
So, Ms. Chervenak asked you how the model was developed, and you told us about cat research, but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people. And in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became the pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time. And so that became the pathway to violence. Does that answer your question?
A little bit. So, but the pathway to violence talks about. Well, strike that. Let me rephrase. So you used the analogy of a cardiologist. You said this isn't predictive, it's preventive.
Right.
Right?
Right.
So this only applies after an event has happened?
No, not at all. That's how we have studied it. How we use it is in advance. So let's say, for example, you are a school principal, and a child in your school has risen to your attention as raising concerns for violence for whatever reason. Maybe he's got a hit list, maybe he's stalking his girlfriend. So I would look at that if I were consulting with you, and I would ask for everything you know about the situation and the child. And I would look for evidence of these 8 proximal warning behaviors primarily that we know to be well correlated with subsequent violence, including the pathway. And if I saw evidence of any of those, then I would advocate for active management of the case to try to reduce the violence risk. The general rule is that once you observe 1 or more of the proximal warning behaviors, then some sort of active management is necessary to prevent violence. So we're managing behaviors of concern in the present to prevent violence in the future. We don't know that the child is ever going to be violent, but we're not waiting around to find out. We're going to take active steps to try to prevent and manage.
And you have no idea if, absent those active steps, would that child ever have committed violence, true?
No idea is a bit strong, but do we know? No, we don't know. That's correct. It's someone can certainly ride the pathway all the way up to one of the upper steps and then never do a thing. That's entirely possible.
All right. So you talked about that it has been subject to many studies. Could you tell me what studies this has been subject to?
Sure. Yeah, I was a little bit surprised to hear Dr. Fox say that it has been subject to no studies. The most recent study that was specifically on the pathway and only pathway came out in 2024 in the Journal of Threat Assessment and Management. And they had a very high, actually high inter-rater reliability score in that study. I would say the majority of studies in the last decade are more on proximal warning behaviors is the label that you would have to search by rather than pathway. They're on, almost more than I can count. Public figures, mass attackers, intimate partner homicide offenders, other sorts of family offenders like paternal filicide, maternal filicide, that kind of thing. Workplace, classroom. The journals are really littered with studies looking at proximal warning behaviors.
Are there any peer-reviewed studies that you can point to that adopt this?
All peer-reviewed studies.
Those are
all
APA.
What are they?
Well, I supplied a list to Ms. Chevernak when they first contacted me, but the most recent one that I mentioned in 2024 is called "Are All Pathway Behaviors Observable? A Quantitative Analysis of the Pathway to Intended Violence Model." And that came out in the Journal of Threat Assessment and Management.
The JTAM is published by the American Psychological Association.
Yes.
Peer-reviewed academic journal.
All right, so it's not a predictive model, it's a preventive model. Right. It's not capable, you can't generate any numerical score, correct?
No.
By using this. And it's not designed to determine if a specific individual is going to commit violence, correct?
No, I agree with Dr. Fox's description that it's a descriptive model. It describes behaviors that have been observed in studies. I would say its operational use is not in prediction but in prevention, which I think is really a key difference in terms of how we use it in the field.
So it could be useful if someone came to the FBI and said they're thinking about a mass shooting.
I'm not sure I take your meaning.
Well, if it's not useful in predicting violence, and it's useful, as you said in your cardiology example, if someone comes in and says, hey, I'm having these symptoms, then, you can help prevent it. So how is this at all useful in the real world? Because people don't come into the FBI and say, I'm having these symptoms, and you can say, well, you are on the pathway to violence, let me help you. That doesn't happen, correct?
Yeah, that's never happened as far as I know, but how it is used is if I'm looking at a case where someone has already risen to the attention of whoever is observing as someone being of concern for violence, maybe they've been making threats, maybe they've been menacing people, maybe they have a hit list, whatever, that can look a million different ways. Then I look at the entirety of the case, as many facts as can be gathered, and then I begin looking for signs of proximal warning behaviors to decide if we're in, sort of an imminent countdown potentially to an act of violence, and that's where the pathway to violence becomes quite useful. If I observe someone on the pathway, particularly in late-stage pathway markers, then I might develop, depending on the context, I'd have a lot of questions, but I might become very concerned that we're close to a potential act of violence.
Has this ever actually happened in the real world, where you have stopped violence based on something that was brought to your attention?
Well,
how can you say that has happened?
We can't. That's what I mean by there's no prediction. I can't. So when we see pathway behaviors or other proximal warning behaviors, we intervene. That's our job, is to intervene. So once we've intervened and there's no violence, how can we ever say that there would have been violence but for intervention? You can't. You can't prove what never happened.
You need to split reality and have it go down two separate courses.
All right. It's fair to say that two evaluators could look at an individual and reach completely different conclusions, whether someone's on the pathway to violence or not, right?
Not well-trained evaluators.
So your testimony is that people always come to the same conclusion if they're trained in this? No. Okay. So people can come to different conclusions, even if they're all both well-trained people.
I think if they're well-trained, they should not come to different conclusions on something as fundamental as the pathway. You can come to different conclusions about how close someone is to violence.
But it's subjective, right? It's not based on scientific data.
Well, it is based on scientific data. All those studies that I referenced in the 80s and 90s that helped Brian Foskule, Randy Vorum, and Robert Fine arrive at the pathway to violence. That's data.
The journal we talked about that it was published in.
No, that's a different journal. There are dozens of studies, but we're talking about the study I referred you to was in 2024, just because it's the most recent one, specifically on the pathway and only the pathway. But the journals I'm talking about we're talking like 80s and 90s.
There's no way that the model can tell us how often it produces false positives, right?
Correct.
And you can't tell us the model's error rate. True?
Correct.
You can't quantify the likelihood that an individual identified as being on the pathway will not commit violence.
I can't quantify whether they will or will not. It doesn't work that way.
Yet you believe you could apply this framework in this case?
I don't know anything about this case, actually.
Well, you know what the defendant's charged with.
I believe it's a homicide, but I don't know any facts and circumstances or if there are other charges.
Okay.
Wow. No, nothing.
Are you familiar with the case United States versus Wells?
I am not.
Isn't Agent Malloy a colleague of yours who helped write The Pathway to Violence?
Agent Malloy? Oh, Dr. Reed Malloy?
Yes.
He's not an agent, and he didn't write The Pathway to Violence, nor did I.
So you're not aware, you gave the example of workplace shooting.
Okay.
So you're not aware that that is the exact case that was rejected as the science being unreliable in the United States versus Wells. You're not aware of that.
I'm sorry, I have no idea what you're talking about.
All right.
What about Crumbly?
Have you testified in a homicide trial about the pathway to violence previously?
I have not.
Have you testified as an expert previously?
I have not.
Yeah, this is not coming in. I don't think it's
Can you
relevant.
give me any examples where the pathway to violence was used in the courtroom at a homicide trial after the fact?
I don't know.
Okay. I have nothing further.
It's not coming in. Judges don't like wading into new areas.
No.
Okay.
Questions, Judge?
Ms. Ammon, thank you. You're welcome to turn off your video and your camera. Why don't we take a 10-minute break, and then we'll come back. Thank you. Come back at 11:10. Thank you. Court's in recess.
Okay. As they take a break,
Manuel,
I want to tell you just a little bit about my my experience with the pathway to violence. It goes like this. Initially, it doesn't look like there's any problem, right? Everything is good. Everything's fine. Everyone's happy. And it's great. And then there's usually a triggering event of some type. I found through my empirical studies, and this has been peer-reviewed, that can involve something just as slight as moving your hand in the wrong direction. That's it. But at that point, the cat immediately switches from purring and happy to kangaroo kill mode, is what I call it, where it uses its front claws to capture your arm and uses its back claws on its feet to do a repeated, like a rabbit kicking or kangaroo kicking motion with its claws out to, eviscerate any muscle which might have remained on your arm. This is the pathway to violence. There's one step. It goes from no problems whatsoever straight to death or attempted murder. That's where we are. So, that's why you put socks on your arm. My cat is an outdoor cat. Kiki's innocent. My cat is an outdoor cat, so there's no claw trimming that happens. Zero. And you at one point you think, oh, he wants to rub up against me. He's purring. He wants food. He wants to, cuddle. And the next moment, it's like, no, he's here for blood. That is the pathway to violence. I have to admit, this seems like a bizarre choice for the state to try to get this expert in this case. First of all, it's a high profile case, right? You know there's going to be experts testifying. And it really makes me wonder if the state might have a weaker case than I thought they had. If they're pursuing these experts. And they've already said we would only bring this in on rebuttal depending on how Kouri testified. But we want to bring, we have to have this hearing. The defense has filed a motion to exclude this witness altogether. Just like, you can't have her on the list. This would be her first time testifying in a criminal case, her first time. And it would be the first time that this pathway to violence would be presented and used successfully in a prosecution. By successfully, I mean argued, not necessarily the outcome of the case. The only other time I can see, other than the case that they cited here about Wells, which I'm not familiar with, that might be a federal case. The only other time I have heard, hey, how's it going, little miss? This brought up was in the Crumbly case, where the prosecutors tried to argue that there was this pathway to violence that the parents should have seen in their son as he escalated from ideation all the way through the planning and the action, right? And so they wanted to bring this in that case, and the judge there said no, it's either irrelevant or inadmissible, can't come in. And so trying to bring it in here where they're not using, I mean, I would have thought that if any case it came in, it would be one like the Crumbly case where they're charged with not taking action, or something like the Uvalde case, where they're charged with not taking action when there were precursor signs that should have alerted any alert adult that there would be a problem. But yeah, so to try to bring this into Kouri in the direct prosecution of her for her. Who would have seen the signs? The victim? Who was supposed to take action? Her lenders that she was, taking out mortgages, and I don't get it. I don't get why they're trying to go there. I think the state has lost their desire really to pursue this. And I think the judge is going to rule this out because, if for no other reason, it has been thrown out before in federal court. It has never been used successfully or never properly been used in any other trial that we know of. And no judge likes to be the one that's like, I'll wade into the water and see how deep it is. They don't like it. They like to tread the path that has been well worn by their predecessors. And very few will be like, hey, there's new grounds. Let's go there. Not going to happen. Not going to happen. We are hearing news that Alan Jackson's withdrawing from the Reiner case. Might be a money issue. Don't know. But Mr. Reiner is going to be represented by a free lawyer until, or unless he changes his mind. So our victim did see the signs. He told his sister if anything happens, he's going to be a kid. Yeah. It's going to be Kouri. I almost said, the other KR. Is Kouri identifying as a cat? No, but Kouri was busting up laughing during this, and just like could not get enough of just. Did she say cats? When asked about how this was, how they came to this, this scientific basis of this, this model, how it came about. Did she just mention my cat? Oh, man. Public defender for Nick Rainier. All right. Nothing in the order. Let's abbreviate Kouri as Kouri to differentiate her from the other KR. Right. We're probably not going to do much else with Karen Reed between now and Kouri Richins. So KR from now on is just going to be Kouri Richins in my head. I'll try to make that jump. But yes. Oh, Melissa. She didn't stop at cats. She went to cavemen, which if you are a scientist and you're analyzing how things happened or why things happened or citing cavemen who no living scientist today has ever witnessed, nor do we have a record of. Okay, it literally, caveman is an idea that we say, well, it must have happened like this. We see that society evolves and we've developed technology and clothes and knowledge and everything else. So we must have gone all the way back to here. Okay, that's where they're at. Science is like, we must have been cavemen because we sure didn't know how to live in houses back then. Oh, I guess we didn't. That's so to bring up cats and cavemen as the proof. I think that was all the judge needed to hear. I think this honestly was a waste of court time. Now, I do think that in psychology that this is a useful tool. And by useful, we're talking about this pathway to violence, right? If there's somebody who you have problems with a student at school, and you're like, hey, what's going on? And they're like, I don't know. Well, on your homework, you're drawing pictures of dead bodies lying all around. But let's get you in to talk to somebody. Just make sure everything is okay. I think it's useful there where you can say we're not preventing something. He might just be like, hey, yeah, I watched, the zombie movie last night and I was drawing the scene that scared me to death. That could be it. But it's not, I don't think prosecution, this has any space here. They use the crudes, yes. Cats and the crudes. They have finger paintings in the caves, that's how we know. But are those peer-reviewed? Don't get me on cave drawings, by the way. I think I've shared this before. My grandpa told me about some Indian writings in a cave, or what's left of a cave. It's now just an overhang of a rock, up a canyon that he used to go to as a kid, and they'd swim in the swimming hole. The canyon's changed so much, the swimming hole's not even there anymore. All the floods and everything has changed a ton. And told me about these cave drawings, and he described where it was. He was in a condition he couldn't really hike up there anymore, but he described it well enough that I was able to go. And just amazing looking at these, just these faint Indian, drawings as, Indian art, like what you'd think, with some things are recognizable and some aren't. You're like, what is that? Clearly those are maybe human. That's clearly animal. But I loved it. Went up there, and then I went up again one time to check them out again and document them with a camera. And they were clear as could be, just right there. Everything was just like it popped out in Instacolor. It was, I found out after the fact that a well-meaning lady, a couple streets over, had heard about them, had gone up and seen them, saw that they were faded, headed to Home Depot and grabbed some red paint and just darkened them in so they would not be lost to time. Every single one she painted over every single one of the historic ancient art. Grr, man. Yeah, don't do that. Don't be that person. Don't be that person. All right, where were we? Why are we talking about this? We are on a half-hour delay, which means even though court has started again, we have to wait the 10 minutes because the delay has to start. So we'll be back in a little bit. Did you stay in the lines? No, she colored some new ones too, which is what really frustrates me. That she used it as her own personal canvas. Yeah. Anyway, all right. Where are we? Where are we in the stream? Does anyone know? How long have we been live? 4.5 hours. I think Kouri Richins laughing was kind of bad. It was, but we were all laughing with her just a little bit. Have you eaten anything? No, I have not. We should go to lunch and then start again. Let's do that. Let's do a quick lunch and come back with more Kouri Richins. How about that? Does that work? We won't miss a thing. Let's see. Create new. All right. Let me get everything set up here. Do I want it? Customization, live chat replay turned on, subscribers only, no live reactions. We're going to be live in 5 minutes, 1:45. There we go. I'm going to grab a bite to eat. We're going to be right back. It's a 10-minute break, so we have almost no time. So, all right. Dismiss. We'll portal over to the next one. I say it's a lunch break, but it's a 5-minute lunch break. I'm sorry. We just don't have much time. Building the portal right now. When we come back, I want to tell you a little bit about the lawyers. I know I was talking when the judge was talking, but the defense lawyers are big-name lawyers. Tyler Robinson, the accused shooter in the Charlie Kirk killing, that's what Miss Nestor's doing. And Wendy Davis, the last big case she represented was Brian David Mitchell. He was the guy that kidnapped Elizabeth Smart from her house when she was 14 years old, from her bedroom, and she was missing for 9 months till she was found on the street, living as his wife. 9 months later, she was returned to her family. Amazing story, but that's big cases, high-profile cases. So, Elizabeth Smart, if you can Google that one, and obviously Tyler Robinson's all over in the news. So, all right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in just a couple minutes. We'll see you on the flip side. Catch the rest of this hearing that's going on right now in Utah, starting in just a moment. We'll see you guys on the other side. Bye-bye.